I would like to call this meeting to order. This is a regular scheduled meeting of the Board of Architectural and Engineering Examiners. It's taking place in Conference Room 1A of the Davy Crockett Tower at 500 James Robertson Parkway, Nashville, Tennessee. And notice of this board meeting was posted on the board website on February 4th, 2014. I'd like to have the roll call, please.
Susan Ballard. Here. Hal Balthrop. Here. Wilson Borden. Robert Campbell.
Present.
Jerome Hadley.
Present.
Philip Lim.
Yeah.
Bill Lockwood.
Here.
Rick Thompson. Frank Wagster.
Here.
Ricky Versailles.
Here.
Laura Reinbald.
Here.
Stephen King.
Here.
Thank you. Guest, if you'd like to stand and introduce yourselves. I guess we've got a few. Go ahead while you're up.
Good morning, Mr. Chairman, members of the board. I'm Nathan Ridley. I'm here on behalf.
Okay.
I'm Robin Ryan with the state and
Never heard of it.
when you
I'm
have
excited.
litigation,
Okay. Thank you. Are there any announcements? Seeing none. Are there any changes of the agenda or additions? Seeing none, we'll accept the agenda. Consent agenda, starting on page 14 of your iPad. Minutes for the December 13th meeting. Have they been, everybody's reviewed them and read them? Are there any changes or other comments? Do I have a motion?
Motion to, second.
Second. Thank you. All in favor, say aye.
Aye.
Any opposed? That passes. Staff complaint report.
That's on page 20 on your iPads. These are all complaints in which the respondent was disciplined in another jurisdiction. The discipline was less than a suspension or revocation, so in accordance with board policy, we issued a letter of caution and recommend closure. You can vote on these as a group.
Do I have a motion to that effect?
So moved.
Do I have a second?
Second.
Do I have any other comments? All in favor, please say aye.
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 Any opposed? So all of those are approved. Professional society reports. Architects, I mean, that's kind of, A kind of moves right.
Good morning, Ashley Cates, Executive Vice President of AIA Tennessee. We don't really have anything new to report other from last December, other than we've set our convention dates. We're going to have a convention here again in Nashville, July 30th through August 1st. You'll receive information about it. And our Day on the Hill is coming up on March the 5th. And you'll be receiving an email soon about it as well. So we hope you'll be there. And we didn't introduce any legislation this year on the Hill. We're strictly monitoring and watching legislation. So that's all we have today.
Thank you.
Thanks.
Candy?
And TSPE. I'm saving you the long names. We're having our Day on the Hill on March 11th. We're going to let AIA turn the turf for us so it'll be a little easier for us. And we're also having Engineering Excellence Awards banquet on March 11th. And I have invitations for everybody. I've given the engineers theirs, but other folks on the board will be invited to come to the banquet. There are a couple of pieces of legislation that we are really concerned about, and I can wait to talk to you about those when we get to the legislative section, or I can tell you about what we have concerns about, specific concerns about now. What's your preference?
Let's wait till the section, because I think that some of those will dovetail probably.
Yes, some of
Some
them
of what
do
we're
and some
doing.
of them don't.
Yeah, that's probably maybe a
Okay.
better deal, if you don't mind.
Thank
Okay.
you, Candy.
I will do that. Thank you. And I'll be back up later. I'm sorry. Jim Mornick will not be here, but I will be asking questions related to qualifications-based selection rule.
Okay, thank you. Nathan?
Morning, Nathan Ridley for the Landscape Architects. As y'all are well aware and your staff is well aware, our legislative friends are fully engaged. Their bill filing deadlines have passed, so you sort of have a better feel now for the opportunities, threats and opportunities that are out there. They'll probably be finished by the middle of April, would be my guess at this point. They'll try to meet last year's adjournment date just because they're a little bit competitive with them. Also because it's an election year, y'all remember that all House members will stand for election in the August and November cycle of elections this year in the odd-numbered Senate districts. So there'll be half of those will be in the electoral process this time. The landscape architects have not, we have a location, but I'm not sure we have our date yet for our annual meeting. It will be in the fall in Chattanooga, which will be a first time for us, so we're pretty excited about that. The planning, and I'm not as engaged in that as I should be, but that is moving along nicely. We're kind of like the architects. We don't have an affirmative piece of legislation that we're trying to pass this year, but we have several that we're monitoring at this time. So, and that concludes. Thank y'all.
Thank you, Nathan.
John Baltimore is meeting with some legislators at this time. He'll be here about 9:30 or 10.
I'm back. So now we are to legal cases reports.
All right, I passed this out to you. It's not on your iPad. And there's not that many cases, so we'll just get started. Under the first heading, new cases, this is case 2013-019901, and this complaint alleges that the respondent engineer was formally disciplined in another jurisdiction because of a failure to maintain required continuing education hours. It just got worse from there. So, in addition to all this, my recommendation is to authorize a formal hearing, authority to settle with this consent order for suspension until providing written proof of release from suspension in the disciplining jurisdiction, and a $1,000 civil penalty total, $500 for each of the renewals that he failed to report to us, and a requirement to take and pass the board's law and rules exam.
Do I have any comment? Do I have a motion?
So moved.
Do I have a second?
Second.
Any other comment? All in favor, please say aye.
Aye.
Any opposed? The motion passes as recommended.
All right, number two, 2013-024101. And this complaint alleges that a respondent engineer was formerly disciplined somewhere else. That resulted in a civil penalty, then failed to report that discipline to us. And this discipline arises from the respondent conducting himself without his license. His license had lapsed. He provided engineering services. Now, the language in the consent order from the disciplining jurisdiction stipulates that the respondent's infraction was unintentional and imposed a nominal civil penalty. It's like $100. From these facts, the respondent was under the impression that this action did not constitute discipline and thus failed to report it to our board. So I recommend close the case with the letter of warning or other discipline subject to board discussion.
Have any discussion?
Wrong, did he say that he didn't? Oh, ignorant.
Well, it seems like this is, I wouldn't say common, but it's frequent, that people believe that agreeing to a consent order means that the matter goes away and they truly think that they don't have any discipline. Seems to be the case here. And I think John sees this quite a bit too, where people fail to report it because they honestly don't think they have a disciplinary record. Of course, that's not true, and I think was it NCAAS has recommended that in our consent orders we put some statement on there that says this constitutes formal discipline. I think it's kind of something that we need to do to keep them from getting in trouble with other jurisdictions too. Because if they see that we consider it formal discipline, they'll feel like they have to report it. But in this case, he doesn't have any complaint history with us, and none of this happened in Tennessee, except for the fact he didn't report it. So I recommended a letter of warning, but I also put board discussion because you may want to do something else, and that's fine too.
Can you like put something in the letter to him to remind him this is actually?
Yes, I'm going to start doing that. I didn't see that anywhere in the consent order that was in the complaint materials, so I can kind of imagine where he'd be under that impression. But I don't think we need to be enablers. Whenever we do something, at least when they get something from us, they'll know that it's formal discipline.
Do I have a motion?
So moved.
Do I have a second?
Second.
You have a motion and a second. Any further discussion?
Point of clarity, what's the motion? Is it for a letter of warning?
Letter of warning with what I just suggested and make sure that,
I think you okay with that? I mean, it's a letter of warning with an emphasis on the discipline part.
Yes.
Okay.
Right.
I'm okay with that.
All in favor?
Aye.
Opposed? Motion carries as discussed, as recommended. Next case.
All right. Now we're under a series that have been reviewed by one of y'all. So we'll just take them one at a time here. Case number 1, I think, is one of Mr. King's. The allegation is that this engineer committed misconduct by providing services outside his area of competence, and in this case, we had an informal conference to try to learn some more about it. So I'm going to turn it over to Mr. King, hear what he has to say.
We did discuss this one last time. It relates to an engineer who put together two sets of plans, and the seals were blurred from the copies we got from the, I guess, the building inspections office in this community. The plans reviewer was suspect that the seal had been placed on improperly. And we talked about it last time. I decided to call this engineer in, and we did that. And we did learn some things about that, and it all has to do with the way he does that. I think there was an architect involved. His seal looks suspect on the same set of plans, and the board office has contacted that architect and determined that that architect did actually do the work. So it's not a situation where a third party got the architect's seal, put it on there, and forged it in essence. But so we did have a lengthy discussion with this engineer about the proper way to do that. He is trying to use a digital seal improperly is really the problem. And what he really needs to do, I don't think he's sophisticated enough to do that yet. He just needs to do it the old way so it looks proper. But in the end, it all worked out very well. We got the plans reviewer on the phone. He's since got appropriately stamped, clearly stamped plans and got the permit. And we confirmed that with the building official. I think the only issue is that we may want to discuss is what action should we take, because we do have rules about the use of the seal, and it looked like you could have made a copy of it and just put it on with tape. You could see the little lines around it, and that's why the building official turned it in. But in the end, everything worked out okay, and I don't think we have any issues with anything other than how you use the digital seal. So my suggestion is, I don't think it warrants anything very serious. Maybe a letter of caution, but This engineer did bring up some questions about the procedure for using digital seals and the authentication that's needed to make sure that the drawing stays under the proper purview of the registrant. And I thought some of you all may be familiar with that and have some input that maybe we could share with him at some point.
Further discussion?
If we send a letter of caution or warning to them, we may want to reference back to that particular section about use of the seal. And from what Stephen is saying, this engineer is not, he's technically challenged. And so maybe referencing back to the use of seal would be good in the letter.
Want to make that a form of a motion?
Well, I move that we issue a letter of warning with specific reference back to the section in our standards about use of seal.
A letter of warning or letter of caution?
Or caution, I mean.
Isn't it
That's-
caution the minimal?
Well, instruction's a minimal, but we reserve that for people that haven't been practicing very long.
Okay.
Caution is just being a little clumsy, and warning is worse.
Caution.
Letter of caution.
Okay. Do I have a second?
Second.
Any further discussion? Okay.
If you want him to, once we resolve this, I mean, he can contact me. I think y'all use electronic. I mean, we can talk about the procedure and the software that you have to use to do the authorization. It's, you know, I feel pretty confident about what's going on there. So just once we resolve everything, he can certainly contact us.
Question. Go ahead. John, do we ever, when the use of the digital seal was allowed when it's allowed in our rule book, do we ever do anything in our newsletter to instruct people what to do with it?
We have in years past. I think when that rule was first adopted back in the late 90s, I believe. I don't think we've published any information on that issue in many years. So that might be a good idea for a newsletter article, potentially. Maybe Mr. Campbell might volunteer to.
I thought Mr. Thompson still owed you one.
That's on a different issue. Okay.
I like to, Mr. Chairman, I like to staff to put as a consideration in the newsletter.
Send me something on it to remind me, because I'll forget.
Let's call for the vote. All in favor, please say aye.
Aye.
Any opposed? Motion carries.
All right, number two, on page 3, this complaint alleges that the engineer failed to maintain necessary continuing education hours. And this material was forwarded to Mr. Lim for his review.
I'll be honest with you, I review a couple, I don't know which one you're referring to. One sender sent it to me, the other one was Francis. So I don't remember which is which.
One Francis sent you, I'm sure. It was
20,
regarding.
yeah.
I don't remember, yeah, if you are put in, because I review a few already.
We'll come back to that one.
All righty. Number 3. This one's 2014, our first 2014 one. 00091. And alleges that the licensed engineer committed misconduct acting outside his area of competence, and this one was sent to Hal. April meeting.
You need a motion to defer it to then?
No, I think
Okay.
we'll just ignore it until April. Number 4 is Mr. Wagster's 2013-024881. And this complaint is about a licensed architect and an unlicensed business being involved in offering services are not authorized to offer. You ready to?
Yes. The complaint is twofold. One is, like Rob was saying, is plan stamping. And it's, in particular, it's about the rules of professional conduct, where it states no registrant shall affix his seal or signature to sketches, working drawings, specifications, other documents developed by others not under his responsible charge, and not subject to the authority of that registrant in critical professional judgments. The second part of that is the complainant says that he has on his drawings and I won't read it, but a little blurb about it being copyright protected. And I'll take that part first. If there's a copyright complaint, that's not the purview of this board. That's a federal discussion. I don't think he's got anything leg to stand on there, but that's not our, so I'm really saying that's just a no review. On the other part, basically what he's complaining about, or his complaint is that it's a convoluted project, but it was a car body shop. It was started by an architect that got sick, and there's a lot of information here. I've got a 25-page response and about that many exhibits with it from the responder. But basically, they took over his project because it had been going on for so long and wasn't getting a building permit. And the people that took it over had actually provided a lot of the information for in other words, floor planning and so forth for the original design. And I'm assuming his complaint is that they took his design and took his drawings and put their seal on them and got an approval.
The architect that became sick is the one who filed the complaint.
Sorry. No, the one that took over after him.
Okay.
And then there was another group out of state that actually ended up finishing the project. It's the one that took it over the second for the sick guy that's filed the complaint. And they sent me digital files of the plans of both the complainant and the responder. And there's not enough similarity there. There is in that it's the same project, but it's a different setup, plan, construction documents. Theirs has a lot of detail in it because this group out of state that did it has done hundreds of these particular projects. And they were basically took over because they weren't getting the permit, and it had gone over more than a year, and it didn't look like they were going to get one. And so the owner changed horses. But I see no reason for the the complainant to think that the respondent had taken their plans and stamped them or even copied their design. Because, there was a structural change even. The complainant's structure was metal building basic structure. The respondent's structure was columns and bar joists. So I mean, there's similarities because it's the same business. But anyway, after going through all of it, and based on what I've seen, my recommendation is that the complaint be dismissed.
Discussion? Do you want to make that a motion?
Yes, I move that the complaint be dismissed.
Second.
Second.
Motion and a second to dismiss the complaint. All in favor? Or any other discussion?
Frank, when you say dismiss, pretty much, would you be willing to, at least from a board office, to give him a letter of caution? Such thing will not happen again in the future? Or is it necessary?
Well, I don't think it's necessary. I mean, you mean to file a complaint?
No, I mean, just to remind him in the future. At the end of the day, when you start the project, you had to see to it, even though he don't have any control in it. I'm just asking, is there any value to give him a letter or instruction, of course?
Give a letter.
It doesn't
I don't
sound like,
think
it sounds like they did everything that they basically started from scratch or semi-scratch to put this thing together, and they've probably done hundreds, like you said, so they just had a prototype that they adapted to that site. I don't think they've done anything wrong.
I couldn't find anything.
Law and rule, Liam.
We've got a motion and a second. All in favor, please say aye.
Aye.
Any opposed? Thank you. Passes.
Okay, the next one, there's 3 in a row here. They were all reviewed by Rick. They're all 3 architects. I think they're 3 separate projects. Okay, these complaints allege the respondent architects were involved in activities that resulted in misuse of their seal. These were sent to Rick, who's currently snowed in. But he did send his brief discussion here, so I'll just read it to you. And if you feel like you need more information, I guess we can always call him later. But this is what he had to say about it. Regarding these 3 complaints, I see that the building design and details are similar in nature, but I do not think the architects are guilty of plan stamping. In my opinion, and I think there's 2 names in here which I believe are the draftspeople. In my opinion, the draftspeople may be at fault for misrepresenting the ownership of the assisted living facility drawings to the architects. As an officer and architect in responsible charge, our firm provides services for a variety of developers on projects that are prototypes provided to us by the developers or the building owners, and we utilize the drawings as our base set to modify to various sites, making appropriate revisions, code updates, engineering coordination, and other pertinent changes to drawings to exhibit responsible charge. I've seen this plenty myself. The board opened the complaints and not the original architect. This is a board opened these. Yes, we dismissed the complaints due to a lack of contractual knowledge and associated circumstances. If the original architect wishes to file a complaint against the draftspeople regarding ownership or copyright infringement of the drawings, that would be more of a civil matter in my judgment. Adds that he would like to dismiss it with prejudice, and we don't really say that much, but what that means is that when it's dismissed, it can't ever come back. Because sometimes these complaints, worse than some boards, they just keep coming back unless you say we're not going to hear it anymore. Public policy being that we've heard it, we've made our final disposition on it, and we're not going to hear about it anymore. Like a similar situation, a prototype. When I was doing design, lots of clients want prototypes and move them here and there and make the adjustments to whatever the site codes and all that are. And that's what this.
I have any discussion?
I think I tend to agree. I mean, we all get things that are prototypes to see if it'll fit on a lot or see if it will, egress or something will work on this particular item, and then we have to put details on that later. So that sounds like this a similar situation. I would agree with Rick's assessment.
Any further comment? Do I have a motion?
So moved.
Second.
Second.
Dismiss.
Okay. Have a motion and a second to dismiss with prejudice.
With prejudice.
Okay. Thank you. All in favor, please say aye.
Aye.
Any opposed? Motion passes.
All right, the last one is a Ricky Bursai complaint. Respondent, who's a non-registrant, provided professional engineering services in violation of our statute. Specifically, in this case, it seems like this non-registrant altered a previous professional engineer's work product calculations. So the allegation was this non-registrant committed unlicensed conduct by doing that. So this was sent to Ricky.
The history on this was we talked about it at the December meeting. There was originally a complaint against a structural engineer at the December meeting because we couldn't find that he had done anything wrong. That was dismissed. There was a report that this structural engineer's stamp drawings had been amended. As the board had his original stamp drawings and then another copy. Code review that had additional marks on them. Those drawings were sent to me and I examined the original versus the ones that had been marked. What was marked on the drawings didn't change the design. A repeat of the exact information or a quantity. If the original drawings had a note about an angle size or bolt size, the
Mr. Bursai, could you, you were looking around like you didn't know. This is God speaking. I'm just kidding.
Yeah.
Where is that coming from? No. Please speak directly into the microphone.
Yes.
It's not picking you up completely.
Do I need to repeat any of that, do you think?
Maybe some of it.
Okay. So when I reviewed the drawings and I feel like I could get a tip after this. Reviewed the drawings and the marks did not change the design in any way. We called the Arizona engineer after sending him an email with the drawings that had the marks on them, and he agreed. They didn't change his design at all. So it seems like there's no basis for a complaint here, and so the recommendation is to dismiss the complaint.
Further discussion? Do I have a motion?
So moved.
Do I have a second? Do I have a motion and a second to dismiss? All in favor, please say aye.
Aye.
Any opposed?
All right, our final complaint, if Mr. Lim is ready. So we'll go back to page 3, number 2.
I was right. It was sent to me by Sandra and Francis, so now there's a couple of them. Actually, this gentleman, his origin state residence is in Alabama, and he actually first registered with Alabama. And Alabama continuing education is 15 hours per year, and ours is based on the 12 months rolling calendar physical date, not calendar date. So make a long story short, he was kind of confused as to what to do. But then later on, when Francis contacted, our staff contacted him to get some more additional information, he did submit some information. Prior to his renewal cycle, he had 12 hours to carry over from the last renewal cycle. So with that said, we put 2 and 2 together, he's actually in compliance now. And also, he went on to file an inactive status that he said that he would not want to practice in Tennessee, also in Alabama too. So it looks like he might be retiring. So I don't know the detail on that, but just looking at the number of hours and all the things he turned in, he's in compliance. More one of this confusion that he had to go through, and we help him sort through. But if he stay inactive, I would recommend him take the law and rule exam. But since he's inactive, I think we need to put a flag in the file. The next time when he reapply for it, I'm sure he has to meet all the continuing education. That would be something that we want to kind of remind him, hey guys, well, you might be registered in Alabama. In Tennessee, you come to Tennessee, you follow our rules and our law. So I would just dismiss the case right now because he's in compliance right now, and put a flag in his file for future when he should reapply again, then make sure that he understood our law and rules and meet our continuing education for reapplication.
In order to reactivate from inactive registration, he would have to submit his continuing education anyway. So, yeah, that would ensure us that he's in compliance here.
Sorry, I got too many emails going on, so I got it. Thank you.
Do you want to make that as a motion?
That would be my motions, Mr. Chairman.
All, is second?
I'll second that.
Thank you. All in favor, say aye.
Aye.
Any opposed? Motion passes.
Right, that's it for the legal report.
Chairman, may I ask a question of
Yes.
Rob? For the newbie here. A letter of caution, warning, all of those, do those constitute a formal discipline action that, given our conversation earlier, I'm just curious.
They're informal. There's
They're
a letter,
informal.
letter of instruction is for people that are fairly new. We hardly ever do that. A letter of caution is, you could have done it better. A letter of warning means that we suspect you've probably done something you know you shouldn't have done. From there, it goes to civil penalties or consent orders, which we can revoke or suspend or impose a civil penalty, and those are formal discipline, and those have to be reported to the national councils.
Application for, okay, thank you.
Apparently, some people don't seem to understand that per conversation earlier, but we're going to make sure they understand it in Tennessee.
Anything else? Okay. Next on the agenda, Director's Report.
We got several reports for your information on the iPads, but before we get to that, I have a few other comments to make. I attended the NCEES Member Board Administrators meeting in Scottsdale last week, and I'll have some information on that meeting later on the agenda. Rick Thompson, Jerry Headley, Frank Waxter, and I have been approved to attend the NCARB Regional Summit in San Antonio on March 6th through the 8th. NCARB is going to provide funding for 3 delegates to attend that meeting. Jerry Headley will attend the Southern Conference of NCARB Board Member Educators Conference in Raleigh on March 22nd through the 23rd, and that's primarily focused on architectural educators in the Southeast. A request has been submitted for Philip Lim, Stephen King, Rob Herndon, and I to attend the NCAAS Southern Zone Interim Meeting in Charleston on April 24th through the 26th. That's still pending at this time. I spoke at a Memphis Light, Gas, and Water seminar in Memphis on December 10th regarding engineering ethics. Mr. Lim was in attendance, and he provided assistance in answering some questions from the audience. I think we had about 35 or so in attendance at that seminar. And Bill Lockwood and I will be attending a career day at UT Knoxville on February the 28th. This is our second year doing that. This is sponsored by the College of Architecture and Design. We're going to be focused on providing information on landscape architectural licensure on behalf of CLARB, but we'll probably get some questions about architecture and interior design as well. We did last year. And for that that particular career day, I'd like to ask for authorization to attend and seek mileage reimbursement for that.
Motion that we allow John to travel and seek reimbursement as part of our policy.
And me also.
Oh, well, no, not you.
Okay.
Only me.
Yeah, just John.
Okay.
Yeah, I
I
forgot, I'm
second
sorry, Bill, yes,
All
you
right,
too.
thank you.
I
Keep
second
thinking you're
that.
Knoxville.
Yeah, that's right. All in favor?
Aye.
Any opposed? That passes, thank you.
Thank you. The Fall/Winter 2013 Design Lines newsletter was distributed in mid-January. That included information about QBS, which of course is on our agenda today, and the open forum with the Engineer Committee to discuss early testing, which occurred yesterday. And I guess Mr. Bothrop will have a summary of what occurred yesterday later on our agenda. The rules that were approved at the August 2013 rulemaking hearing have been approved by the Attorney General's office. I'm not sure if we've gotten them back yet, but okay. They're on their way. We've been told that they've been approved, and they'll soon be filed with the Secretary of State's office. They'll take effect 90 days after filing with the Secretary of State. So I'm guessing the effective date will probably be in May at some point.
I hope so.
Yeah, that's our hope. So it's been a long process because I think we had to send them back to the AG a couple of times with revisions. So it's been a lengthy process. Give you an update on the grant contracts. All of the contracts have been approved with the exception of Lipscomb, MTSU, and UT Martin. Those three are still pending approval by F&A. For the rest, the funds are in the process of being distributed to the schools. The effective date was February 1st, so we couldn't distribute any money until that date. And also wanted to give you an update on some strategic goals that have been established by the department for the current fiscal year. Some of these have changed slightly from what the goals were previously. One goal is to fully implement a new licensing system which we've talked about to replace our current regulatory board system by September 2015, and the hope is with this it will facilitate a full online licensing. The goal, I believe the goal still is to have the system online activated by the end of this year, but the online licensing component is, the goal is to have that implemented by September of next year. So hopefully, as of that time, we'll be able to put our applications online so they won't have to send them via the Postal Service in the future. Another goal is to assure that 75% of complaints are resolved or authorized for a formal hearing within 180 days of receipt. That goal was previously set at 70%, which we far exceed in our measures. But that's been moved up to 75%. Also, they want to reduce average licensing processing time across the division by 5% in fiscal year 2014. This is going to be achieved partly by eliminating the revenue lockbox. Revenue processes our renewal payments that are submitted through the mail currently, and the goal is to move that processing from revenue to our department. So it'll be done in-house, and it's hoped that that's going to reduce processing time by at least several days, because there tends to be quite a bit of lag time between the time the renewals go to revenue and they get to us. And I've recently checked our system to see how many registrants were renewing online, and right now we've got about 52% of our renewals that are completed online versus paper renewals. I also wanted to bring to your attention that, I mentioned this to the engineers yesterday, that we're starting this year, we've always taken notes on committee meetings, but we've never actually recorded them as formal minutes before, to my knowledge. So we're beginning this year. This is sort of a best practice that's followed by several other boards, like the Accountancy Board. Beginning this year, we're going to start recording formal minutes, similar to what we do for the board meetings of all committee meetings, and those will be approved by the committees and then accepted by the board along with the minutes we have for board meetings in the future. So just wanted to bring that to everybody's attention, because that'll be one of the items on your consent agenda to accept committee meeting minutes. And I believe that's it for those comments. Licensing data is on page 21 on your
Real quick,
iPads.
before you go to
Yes.
licensing data,
Sure.
you mentioned the online registration system. How does that handle the reference? Is there a mechanism to bring references in under something, or do we have no idea
Well,
yet?
that I don't know. We're already receiving quite a few references by email, right? Or sometimes fax, other means other than through the mail. I don't know, though, if that's going to be part of this online system or not. I have a feeling initially it may just be the application form, and it'll be set up to receive their payment, and other supporting documents will probably receive separately from that. But I'm not sure, because they haven't given us a preview of that system yet.
How much input will you and the staff have on that, or is it just kind of an out-of-the-box system, or is it
Well,
have some specialized?
Yeah, this new system is going to be, it's by the same company. It's changed names over the years, but it's essentially the same vendor that produced our current system. So it's not going to be dramatically different from what we're currently using. It's just going to be more of a web-based system than our current one is. But they are working closely with us, but there's certainly a limit on how much it can be tailored for our specific use, because it's going to be used across the division. Cosmetology, barber, motor vehicle, accountancy, we're all going to be using the same system. So I'm sure there's a limit on how much customization is possible. But again, since we haven't really gotten to that part of it yet, I'm not really sure how it's going to proceed.
Hate to see something cause us to have other difficulties that we find important just for the sake of automating something. And references are one of the things that kind of pops in my head, that making sure they're all tied to that registration process, I think, is important.
Right. As I said, page 21, you have some licensing statistics. This is just for your information. The next page, you have applications received, approved, or reviewed and approved, I should say. Complaint data beginning on page 23. That report beginning on page 23 just gives you a snapshot of all of our open complaints as of February the 4th. And on page 24 of that report, you'll see some of our statistics, that we have 12 that were at that time open over 180 days, which is 34% of all of our complaints, but 0 over 180 days without clock-stopping action, where a formal's been authorized or a consent order issued or something of that nature that would stop the clock. We've got 9 authorized for formal hearings before the board, 1 to be heard by an ALJ, and our percent on time in the last 18 months is 95%, which is well above our new 75% goal. And other statistics beginning on page 25 for the current fiscal year and also cumulative of the last fiscal year. Financial report begins on page 27. Yeah, Rob asked if he could borrow some money, but we can't. Yeah, you'll see our revenue experienced a slight decrease, only about 18,000. Nothing that indicates a trend that we're bleeding money, certainly. Expenses did increase quite a bit versus this quarter last fiscal year, but that is almost entirely because we paid all expenses for the October engineering exams this quarter, this fiscal year. Last fiscal year, those expenses were paid in the third quarter instead of the second quarter, so that's the reason for that. Nothing unusual. And you do have the details behind that, the summary, if you want to explore that in the pie charts, the pretty pie charts. Entertain any questions if you.
John, I've
Have
got
any?
a question. When the engineering exam goes completely computerized, are we going to have any expenses for that?
No, that most of those expenses are going to, actually, all of them, I should say, the engineering exam expenses will go away. But our revenue will see a decrease as well because we're not going to be collecting those exam fees. So in that sense, there'll be a slight decrease in revenue, but we're not subsidizing the FE exam, $75 per candidate anymore. So that'll offset a lot of that revenue decrease. So I don't think it'll affect us very much ultimately because both we will see a drop in revenue, but we'll also see a corresponding drop in expenses. So bottom line, I don't think it's going to affect us very much. In fact, I think it'll increase our revenue because we're not subsidizing the FE candidates. All I have.
Going to the engineer committee report.
Okay, we had our meeting. And we started the meeting with an open forum to discuss the prospect of allowing engineering candidates to sit for the professional engineering exam prior to our current model, which is required 4 years after a qualifying degree. John had advertised quite successfully, and we got some feedback electronically originally, and then we were visited yesterday by Ms. Candy Toller, representing the Tennessee Society of Professional Engineers, and Monica Sartain with the American Society of Civil Engineers, and also a representative of TSPE from one of their local chapters. We allowed all of the technical society representatives to share with us the feedback from their respective organizations. We had good conversation and explanation on some of the content of those comments. And our current position is that we are still under advisement of making any determinations on whether to modify our current practice. So all applications as of now will continue under our current statute and policy. We will continue the discussion in subsequent engineering committee meetings over the next several months. Report back to this board when we have more information on that. We also had a variety of applications for review, and those were handled in customary fashion. We also had a couple of applicants, one by phone and one in person, come in for interview for eligibility for sitting. Also had a conversation with a representative or an officer from the southern zone of the NCEES, Mr. Dan Turner, PE, and discussed the prospects of travel to NCEES events that serve to determine policy and practice as it relates to our industry. Currently, we are limited in the number of attendees that we can send based on finances, but also based on any conflict of interest that might exist because we have a contract with NCEES. Interestingly, that contract will expire June 30th of this year due to the computer-based testing format of the FE exam, and subsequently in future years, the professional engineering exam will also be computer-based test-based. But for now, we have our delegates selected for the Southern Zone meeting, which will occur in April in Charleston, South Carolina. And then we have our national conference in August this year in Seattle, Washington. We will John reported from an NCWS member board administrator meeting that he attended just recently and provided information relative to that. I'm sure it's included in his report. Task force, of which I sat on for NCWS, dealing with experience of foreign applicants. And we shared the results of the task force or recommendations of the task force, which will be taken under advisement or under vote this summer at the national meeting. Many states are experiencing an influx of foreign engineering applicants, and we just are trying to establish a basic standard that would be fair to them and also fair to our domestic licensees, all in the protection of public health and safety. So we'll report more on that in the coming months. We also dealt with an issue from a licensee, Mr. Joe Carson. Now or talk about it later, Mr. Chair, I'm sorry. Would you like for me to continue or wait?
Go ahead with, as
Okay.
part of your committee.
Okay. Mr. Carson had submitted, he has come before this board before, dealing with an issue of, in his opinion, of public health and safety with his employer, which is the Department of Energy. He had submitted a letter for consideration to the engineering committee. We did review the content of the letter, discussed the merits of it, and determined that we want to recommend, well, let me back up. The letter from Mr. Carson was actually addressed to you, Mr. Lockwood, and so the board will need to take whatever action, but the engineering basis of his letter is that he is asking the board to advise him on next steps based on his situation. One is that he asks if we feel that it merits that we, the board, recommend to him to resign from his position of employment. Or he's asking that if that's not the case, then to somewhat substantiate the claims that he has made relative to his employer's impact on public health and safety. Our committee, after much discussion, has determined that we're recommending to this board that no further action on our part is necessary unless, based on all the evidence that has been presented heretofore, he has pursued action through other jurisdictions relative to any threat to public health and safety. But our committee recommends that the board does not have any more compelling information that would warrant a advisement. Other content of the letter or suggestion that or recommendation we make to the full board is that unless Mr. Carson has further evidence in addition to what he's already presented, that there's really not board consider on action relative to this issue. Okay.
On to the,
You may have, do we need to vote on that?
we'll vote on
New
that.
business?
We'll vote on that in
Okay.
the new business as the committee. We are now into the legislative update.
Mr. Lockwood, our legislative person in the department is not here yet, so if it's,
Move on to the
if it's your
next
will, we could
unfinished-
move on to the next one. or-
Yes. Unfinished business?
Okay. Let's see. Page 66 are action items from the December meeting. Let me get there. 66 on your iPads. I did send a letter to the Department of Health regarding a case that was presented in December expressing concern about the safety of the project in question. Also sent a letter out advising Tennessee colleges and universities of our opposition to use of the term interior architecture by interior design programs. And Susan, did you want to, well, we got some information about this issue subsequent to the mailing of that letter.
I called the University of Tennessee because they're entertaining the name change as well. And I spoke with the executive assistant to the dean, Scott Poole, explained to her the position of the board, why we have taken this position. If they want to pursue something with the state legislator body to incorporate interior architecture as a new profession, that's the route they would have to go. But at this point, Tennessee doesn't recognize it, and we're asking that they, work with us. If as a collective group of colleges, they want to make a name change based on a new profession with all the things that go along with it, that's how they need to pursue it. I've not heard a word since, so. But I know Chattanooga has had the conversation, ETSU's had the conversation, and I believe Memphis has had the conversation, so.
Also, of course, we did publish information on qualifications-based selection in our last newsletter, and we will schedule a meeting in April to further discuss that issue with representatives from CTAS, MTAS, Municipal League, and other parties. And everything else has been taken care of on action items, so wraps that up. On page 60,
When
yes.
did you said you had scheduled the meeting in April?
Well, no, we haven't yet, but
Okay,
we will
okay,
be,
okay.
yeah. Not yet. Page 67 begins potential rule changes for discussion, which were also presented at the last meeting. Not a lot of new changes here. We did want to further discuss under all professions, the rule to provide for expedited issuance of licenses for veterans and their spouses, waiver of renewal requirements for those on active duty, et cetera. As you'll recall, we had talked about a proposal to provide temporary permits to certain individuals that meet the criteria. And the board was not in favor of issuing those type of permits. So then the issue came up, well, what sort of process should we adopt to provide for expedited issuance of licenses to veterans and their spouses? And, Rob and I have talked about this. I've talked to some other directors about it as well, and still a bit in a quandary as to how to proceed with this, what would be the best method. And the surveyors board's dealing with the same issue, so the engineers are going to be meeting with the surveyors in April. So that's one item that I was going to place on the agenda for us to discuss with the surveyors board, is how to proceed with the implementation of this law. I talked to the accountancy board, and they have had a provision for temporary licensing for years. So they didn't have any heartburn about this particular issue. They just adopted the recommended language. So that
John?
wasn't very helpful.
Excuse me.
Yes.
John, what about, have we seen any architects or interior designers that might fall under this?
Well, no. Nobody's contacted us about it. I think it would affect a very small number of applicants. Probably more engineers than any other profession, but it would be a small number, I'm sure. And the accountancy board, they said they haven't issued a temporary license in years, so they don't expect very many applying under this provision either. So I don't know if you want to have any further discussion on that, but I think that's an issue. We may just have to wait and see what other boards are doing, wait till we can discuss it with the surveyors. Maybe we can get some ideas from other agencies on how to proceed with that. I guess as far as a rulemaking hearing, we might be able to plan on another one in August, potentially. Rob left, depending on how this issue works out. And based on our discussion on QBS, It's possible we may want to make some tweaks to that particular rule regarding qualifications-based selection based on a conversation that Rob and I had with an attorney recently on that rule. I guess, when Rob gets back, we can talk more about that. But that's all I have on rule changes. Then beginning on page 72, you have information on qualifications-based selection. This is leading up to the correspondence that we received from James Morinek regarding transportation planning services. But here you have the new statute, 124107, that covers contracts for professional services. And then behind that, page 73 on your iPads, I have a revised notice. You'll remember we published this last year. This reflects revisions to incorporate the new statutory reference to add landscape architects, which were not included in the original notice, and to remove the reference to local projects, since now it's both state and local. So I suppose if you want to publish this, you might need to make a motion on that, if you're okay with this wording.
Do I have any discussion from the board? Do I have a motion?
So moved.
Do I have a second? All in favor, please say aye.
Aye.
Any opposed?
And then you also have the FAQs beginning on page 74, which are, a couple of those questions are still to be further discussed. And Candy had actually suggested that in a few places, and they're highlighted on the FAQs here, I think there's 4 questions that talk about professional design services. She had suggested perhaps taking the word design out and just referring to professional services, since saying professional design services may give people the impression that it only applies to actual design work, when the types of services architects and engineers provide, and landscape architects might fall beyond that, so go beyond that. So that was a suggestion. That can be further discussed later, since we've still got some other revisions to make. Well, we did already publish the majority of these questions, and I think the expectation was that we may draft some additional questions following our conversation with MTAS, CTAS, other groups in April, and then publish them, a revised set of questions, probably in our next newsletter or future publications. I guess this could be further discussed in April. And just since Rob is here, let's go back to the issue of the wording of the rule. And you have the text of that rule on page 73, that notice that everybody just voted on. Gives the text of that rule. It's Rule 0120.02.02, paragraph 6. And right now it reads, a registrant may not enter into a contract for professional services on any basis other than direct negotiation with any governmental entity that is prohibited by TCA Section 124106A2A. And we had already proposed for our next rulemaking, we're going to have to amend that to refer to Section 124107A. It goes on to say, from making a selection or awarding a contract on the basis of competitive bids, thereby precluding participation in any system requiring a comparison of compensation. And it goes on to say that they can only state compensation upon selection. In a discussion with an attorney recently, you want to go into that, Rob, or want me to summarize it? Well, he said that it specifically says a registrant may not enter into a contract for professional services. He suggested that probably should make reference to submitting a proposal, rather than specifically entering into a contract. He said that could be interpreted to mean that you haven't violated this rule until you actually sign a contract. If you're just submitting a proposal, a bid, that's not a contract, and thus you haven't violated the rule. That was the argument that he was making. Now, it does go on to say thereby precluding participation in a system requiring a comparison of compensation. But he says, well, that modifies the first part of that sentence, enter into a contract. And let's say if an architect hasn't entered into a contract, it's not technically a violation of the rule. And I did look back to some of the wording of used in other states. And the language we adopted is based on South Carolina's language. It's very similar to our rule. Nevada, their language actually says an architect, residential designer, or interior designer who holds a certificate of registration shall not submit any information to the state of Nevada or any of its political subdivisions as part of a proposal for a public works project, which would enable the public agency to evaluate the proposal on any basis other than the competence and qualifications of the registrant to perform the type of services required. So they actually talk about proposals in their wording, and it was suggested that we would have to change the wording, obviously, to fit our specific circumstances, but perhaps wording along those lines might be clearer than just referring to entering into a contract. So just a suggestion.
I like the Nevada wording. Because, because I had at our last board meeting, I had 3 complaints about an RFQ, and if we were specific with using proposal, I think that clears it, makes it a bit clearer for everybody.
But if y'all think that's a good direction for us to go in, then Rob and I can work on adding that change to our proposed rule changes for consideration. Try to draft some wording but similar to Nevada's language, perhaps.
If we put this language in a rulemaking notice, the public will show up and give comments about how they feel. We'll learn more at the hearing. It looks like the statute contemplates bidding. The statute does, but our rule contracts. At any rate, this is a distinction, enough of a distinction that it's causing a problem in the big wide world. And some people think that bidding is not. I seem to think that we discussed what bidding was included, but I'm not, my memory might be faulty. In this particular case, the governmental entity was asking for particular information, and of course the bidding licensee felt compelled to comply with that, so they felt there was a type of entrapment there. There's enough problems where we need to redo the rule.
Yeah, it's just a case where we just borrowed the language from another state, and maybe their law may be worded somewhat differently from ours, but probably the language does need to be a little clearer, that proposals are included, not just contracts.
I think that's the point.
Yeah.
It seems like that.
On maybe proposals and and bidding.
Well, it says procurement process, which if you think about it would incorporate all of it. But then there's enough language throughout the statute and the rule that it sort of gets ambiguous. What do y'all think?
Yeah, speaking to the microphone, please.
All of the different types of determining qualification selection for a project ultimately encompasses proposals,
trouble for people. And the last thing we want is to be disciplining, and it doesn't.
Is Michael, are you here for part of that? Transportation, QBS?
Yeah, you can move on to the correspondence by James Morneck if you would like at this time. That's on page 78 on your iPads. Do you want me to read this letter into the record, this email, I should say? Here's the correspondence from Mr. Morneck. A municipal planning organization has issued an RFP for transportation planning services that indicates 20% of the selection evaluation will be based on cost. The notice issued by the board in June 2013 clearly indicates that cost comparison could not be used as a basis for selecting architectural and engineering services for local public works projects. It is not clear if the rule applies in this case for several reasons. One, would the board consider a transportation planning project to be a public works project? The plans form the basis for guidance that could result in roadway and/or transit construction projects. Two, while the board does not grant licensure for planners, the work involved in planning projects is frequently performed by professional engineers. The June 2013 notice issued by the board specifically references the most qualified design professional firm. If the work can be performed by planners and/or professional engineers that are not licensed in Tennessee, would the board have jurisdiction over the firm that they work for if the firm has an office in Tennessee? 3, metropolitan planning organizations are not specifically identified in the code. However, in this case, the MPO is embedded under the Planning Commission of a metropolitan government. As such, would the prohibition on seeking professional services under a cost comparison basis apply to them? This seems to be a recurring issue, and your guidance will be greatly appreciated. And then I have another email related to this issue by Candy Toller, emphasizing that engineers have been struggling with the issue of planning and whether it's considered engineering. And then I also, just for your information, I provided some information on MPOs from the Nashville area MPO website, and then an opinion from Mr. Skipper, who's in attendance at our meeting today. So, it's open to discussion.
Hear from Michael? Yes, come on up.
Morning, pleasure to be here. My first Board of Examiners meeting, and I'm interested to see how this process plays out. I'm here this morning to answer any questions you might have about the...
State your name, I'm sorry.
I'm sorry about that, Bill. Michael Skipper, Executive Director of the Nashville Area Metropolitan Planning Organization. And I'm here to answer any questions you might have about the nature of the work that we're trying to procure through the Access Management RFP that's been... Historically, MPOs has been are sort of have a closer relationship with the Tennessee Department of Transportation than we do our Metropolitan Planning Commission, which serves as the fiscal agent to our MPO, because MPOs aren't recognized by state law; they're a product of federal requirements. And historically, with respect to the requirement that precludes agencies from requesting cost proposals for architectural and engineering services, our understanding working with the Tennessee Department of Transportation was that it didn't apply to the type of long-range planning work that MPOs do, or even that the state DOT does within their long-range planning division. We also sort of have formed our opinion about our exclusion from the application of this statute based on sort of our relationship to the Brooks Act, which clearly hasn't folded in the long-range planning activities that we do into the requirements there that preclude cost proposals to be part of the consideration. I guess just to reiterate my opinion about the matter before I answer any questions you have about the issue is that we see a clear distinction between planning that would be done within the form of an NPO and planning that would be done for the purposes of engineering a project. Planning and studies are conducted in both sides of the decision point to do a project or not. But the type of planning we do is typically policy-oriented. There may be some consideration for design recommendations that can serve as guidance to projects as they are defined, then ultimately implemented through preliminary engineering type studies or environmental studies that are part of the project development process. That's what I was trying to establish through the email to Candy. I'd be happy to answer any questions about the nature of the work that we're doing. I don't think I'm suggesting that there needs to be any changes to the statute or the rulemaking. I'm just merely pointing out that I think there's varying degrees of planning that happens in our world, some of it being more engineering related than others, and the type of work that we do certainly, I think, doesn't fall into that category. That being said, oftentimes we have engineers working on planning studies, but but we're not requiring that engineers conduct the type of planning that we're requiring through our planning activity.
I'll start off here. Although Steve's probably got some information on this too, because he deals more closely with NPOs than probably anybody here. First of all, thanks for being here, and we understand this has got some different angles to it, and we've been struggling with where we are, and the reason we are where we are is that we have taxpayers and citizens that have been getting taken advantage of by having unqualified design professionals doing projects. At the end of the day, those projects endanger the public health, safety, and literally can cost much more over the life cycle of those projects. My interpretation of planning, we've had this discussion on, and I'm kind of being long-winded to give you a little history. We've had this same discussion on subjects such as commissioning services, and it's a similar thing in my mind. That you're exactly right. There probably are aspects of planning that are planning, demographic studies, just off the top of my head, that are planning functions. Where I think that line gets crossed is when those numbers are used to develop or used in conjunction with engineering numbers, traffic counts, traffic data, traffic generation models, capacity modeling, potential budget, engineered budget estimates that would come about. We consider that engineering. I mean, it's in actually some of our evaluation statutes when we're looking at an applicant for engineering. And so if it's purely planning, and I know those things are intermingled a lot of times, I would say you're exactly right, because there are parts of planning that are just how many people are going to be in a certain area, what's the best public policy for this area, and all that. As I look at the correspondence, I'm not sure exactly how you can separate the two if you're using engineering numbers and engineering analysis to come to a conclusion on a planning document. Obviously, you have to have, those things are married together. And we have, our line is drawn for the reason I stated, because those numbers have to be done in a lot of cases by engineers. You don't have those trip generation modeling and some of the traffic analysis are not done strictly by planners. They're done in conjunction. So I would consider, and I don't know 100% about your application, but if it's got the engineering data, the engineering analysis, even though it's on a cursory level, I personally would, no, I shouldn't say we because the board's, but I personally would consider that to be an engineering function, in my opinion. So
Well, if I
ahead, go
may
ahead.
just offer a point of clarification. So the modeling that we do is done by planners. I hire planners to do travel demand models. There are engineers that do this modeling, but this is not the type of modeling that's done at the level of detail that you would use to do sort of, say, evaluation of traffic flow and operations around an intersection. This is a different kind of modeling that we're talking about. The regional travel demand models that feed into planning studies are much more coarse, don't require an engineering background to build or run, although there are overlaps in the profession. Some engineers choose to do more planning-oriented work than other engineers, but there's no requirement that an engineer build or maintain or run a regional travel demand model.
Do any professional services of any kind, or should they be based on cost, either in part or whole? My thought on that is, aren't there contracts in other jurisdictions of a similar nature that could give one a basis? Secondly, I'm a little concerned that the potential offers of services for these types of things all for trying to comply with the statute might raise all-encompassing thought is it necessary to include cost, even at this level of work? Best out of the proposals or qualifications that are submitted, and just recommend maybe you consider, regardless of whether engineers or architects participate in the.
Yes, sir, those are great observations, and from a practical standpoint, I can explain how we use cost in the evaluation process. Everybody knows the budget we have for a study. I'm real transparent about that. It's in a public document. For this particular study, I've put it on record that our budget will be $300,000. When the budget is known, you may not be surprised that we get no variability in the cost proposals at the aggregate level. Where we use the cost proposals on our evaluation is in understanding the level of participation by DBEs and by understanding the level of effort that each consultant, because planning is much more gray in general than engineering, right? To understand the level of effort that each consultant is putting into individual tasks. It gives us a better understanding of where they're placing priorities. And it demonstrates that because the nature of the proposals that we get for our studies are mostly varied based on the specific scope of work. It's a documentation of their financial capacity to deliver the unique aspects of their scope of work. This isn't to do with qualifications of the individuals of the companies performing the work. So that's how we use the cost proposals in the evaluation process. Isn't to select the cheapest proposal over the most expensive proposal. Like I said, the variability between the ultimate price is very small, and we have routinely picked the most expensive firm of the lot to do the job. So that's how we use it. Having said all of that, I do think there's a clear distinction between the type of planning that we do at an NP level than the type of planning that would go into the project development phases of projects that come out of the planning process. But I have a great relationship with our local engineering community and have promised not to put them in a situation that would lead them to possible discipline. I'm willing to sort of amend the RFP to go about this a different way. But I think it's still worth addressing the core issue here, which is that whether or not long-range planning, which doesn't require architectural engineering services, should be subject to the rules of that sort of are promulgated from the statute. And this, in the short term, I'm happy to do whatever I need to do to relieve the burden from.
One follow-up on your DBE suggestion, and I understand offers put percentages, and they're not specific to costs. And then
A question, really, it's much more for the board, but to think about our rules about stamping, sealing includes not only designs but reports. And my question is, with these type planning reports that Michael's talking about, if a registered engineer does that planning report, would we expect that to be stamped? Or would we say, no, that's not the type of report that needs to be stamped?
in accordance
The engineering data in it, I would say you have to.
You have to stamp it.
Yeah, if you've used some sort of engineering analysis, I don't see how you can get around not doing.
That would lead me, then, the next step would be that procurement of those services for a registrant would need to follow this rule that we have, and which leaves us a gray situation, because if you procure the services of non-registrants, you can, there's no rule there that would, I guess, that would say that you can't ask for price. You could ask for price. So I'm not sure how to handle that, but if you're a registrant, it makes me think the registrant is going to need to not propose a price with his services.
And Mr. Skipper, would you say that you or your designees have the authority, as long as the procurement rules are followed in the selection, and then once the selection is made, will you have full control over the negotiated costs for services under?
Yeah, I mean, I think I can make this work without asking for a cost proposal, as long as I can assess the level of effort. However, I see two distinct issues here. One is what I'm willing to do in order to accommodate the fears of the engineering community. The other is whether or not this applies, because I'm not the only NPO in the state. I'm not the only political jurisdiction of the state that's going to be engaged in planning studies where engineers may have an interest in performing work. There's no requirement by us, and I fail to see the applicability of requiring any document to be stamped or sealed in the deliverables that we have. And then how do I manage that? Am I requiring that the engineering analysis done by engineering firms stamp their report, and not the planning firms that are submitting on the same work? I mean, that's to me where there's the point of departure, is that there is no requirement for architectural engineering services to be performed by our agency. Engineers sometimes choose to do those planning services that we are requiring.
Part of what we're trying to, look at the big picture or the potential as well as the reality of. And we understand your situation. I might ask too, there's an organization of MPOs in the state, is there not?
Formal organization, but we are a small
But
community.
you're right. We will be obviously dealing with this probably on a larger scale across the state. This point is going to set a precedence on how it's going to be applied everywhere, and project you're trying to get out until we kind of come to maybe hopefully a mutual solution. I would encourage you to consider doing that at least at this point, so, and then continue conversation.
If I may also clarify that I don't think this is an NPO versus another agent. I mean, what if the Metro Planning Department needs a consultant to update their local comprehensive plan? Engineers are likely to have a business interest in performing those activities, but are we now requiring local planning departments and updating their local comprehensive plans to require this of their engineering community? And I think that's a burden that is probably disjointed from the intent of the statute.
Burden. I guess I'm a little conflicted with that because I wonder, in your terms, what do you consider a burden?
Burden on the engineering community as to whether or not they're going to propose on a project because of the cost proposal requirement.
Agreed, and that's why, to eliminate that and as part of the selection, you would still get a qualified firm and you would still have a basis because there's, none of the work that we're doing right now is original or hasn't been done in other jurisdictions. And there is this resource of information to find, and we use it all the time at the water department. How much did this type of work cost in this particular utility? And we use that as a basis for negotiating fees and that kind of thing. So I guess my point is, if you have full control over the budgets that you spend for services of this nature, you still have the protection of the interest of your constituency by virtue of that authority. And it might be necessary to include that in a selection process that would then cause the potential for engineering groups that might be the best, that want to offer, to feel that they may not be allowed to because they would be in violation of statute. So the whole thing would go away. You would still get the qualified selection, certainly, and then you still have a power and authority to determine the fees that would be paid to the selected party.
Again, I don't think I disagree with that philosophy. What I'm saying is the burden that's placed on the engineering community because you have no purview over planners who may be proposing on that same type of work. That's the distinction I'm trying to make. It isn't that I disagree with you in terms of the benefits of not requiring a cost proposal. I'm saying it's unfair. It's a disadvantage to the engineering community who has a business interest in planning work to have this requirement placed on them when there's another professional community out there that's not subject to the requirements that come from the statute.
Understood.
The disadvantage comes when you ask for price, correct? So what I think Mr. Balthrop is suggesting is that if price is not the only way that you can make a qualified base selection, and I heard the DBE and that in some instances can be a robust project approach in the proposal could take care of that. I didn't hear anything else, and perhaps there is another reason why cost would give you more information that's required to make that selection.
Well, one, it's streamlined. The procurement process already takes way too long to get through the selection process, get into contract negotiations. It could be a 4 or 5 month process just to get somebody hired. And disjoining the cost proposal from the selection process just adds time to that. But I guess what I'm saying is that the clarity in the statute, you've got planning departments across the state that have no idea this applies to them. They're issuing RFPs for planning services, and there's fear in the engineering community about the disciplinary action that they may receive from this board. And that's the distinction I'm trying to make. If the state wants to pass a law that specifically spells out planning in the statute as being part of this provision, then I don't know that I would be against that. But in practice today, you've got, like I said, all types of planning departments issuing RFPs for planning work that are not complying with the state
And that's
law.
a transitional issue
Yes,
as well.
that's exactly
And so what we are grappling with is how to help our community through that transitional issue and also apply the statute. One more point of clarification. When you talk about not requiring architects or engineers to be a part of this planning, when you're not requiring, I wanted to, and correct me if I'm wrong, but this board has taken action against registrants for responding as a registrant to a request for proposal that did not require architectural engineering professional services, but did respond in a manner that offered architectural engineering services, and the board took action. So I think that's an important distinction that you might want to might help you in understanding where this board has gone in applying the statute.
And we have just recently clarified that. And we would like to work together to mutually benefit our respective constituencies to make sure it doesn't continue.
In order to carry this out, I need guidance. The next RFP is going to be looking at, freight-related policies. There may be engineers that have an interest in performing that work, but I can't guess at that. And just the uniformity of how I go about my business or any other planning department goes about their business, not having familiarity with this board or the statute, having not known it applied to us for years, is just going to be something that's difficult for us to deal with while also getting our work done. And like I said, up to this point, most of my understanding about A&E services is defined by the requirements of the Brooks Act, which and the guidance from Federal Highway Administration and Federal Transit Administration says you look at the preponderance of the work that you're requesting through the RFP to determine whether or not the preclusion of a cost proposal applies to the specific study that you're seeking. Having said all that, as an individual, I'm willing to be flexible on the matter and will amend the RFP. But I think there's a larger issue here beyond what I'm willing to do or not that we need to address.
I agree with you. And appreciate your flexibility, and we're trying to be flexible as well because we understand this procurement and RFP process can take a pretty good period of time, and that's one of the reasons we're setting this meeting up in April is to, it's a burden on you all to do the review and go through this. It's also a burden on the people doing the RFP if there is a budget or something that they know they can't possibly, scope that they're not going to be able to get to. So you might as well not propose on something if it's unrealistic for your firm to be able to do that. So we want to try to come to a good understanding of what that is to make this process better for both, with the caveat that our purview is public health, safety, and welfare. I mean, at the end of the day, and then I'm not saying this to be cavalier, but at the end of the day, if this process takes 2 years, but we're protecting public health, safety, and welfare, then that's fine. I mean, and again, that is kind of a cavalier statement, but that's what our focus is on. And I would say that one quick thing, we do have jurisdiction even over people doing planning documents if they're using engineering data and bringing that out, because we have non-registrants that we have the ability to discipline, and we have the ability to fine, and we have the ability to do that if they're using engineering data on some level. And again, we have to argue about that a little bit, but on some level, so for instance, if you had a planning organization or planning company and they were doing queuing theory models, I'm going back to something I remember in school, that's about it. But that would maybe be considered an engineering function that we would have some jurisdiction if they provided a document that didn't conform. So we're not trying to. We've got a mission that we see as being damaged potentially by cost, because there are other jurisdictions that are using cost as the basis of selection, and that puts the public at a tremendous health, safety, and welfare disadvantage, and we have to cut that down because well, it's just the right thing to do, for one, and number two, it could be a tremendous burden on the taxpayers later on as well.
Just, beg you to keep in mind that any recommendation that comes out of a long-range planning study is going to get into the project development phase, where preliminary engineering, even alternatives analysis, I would consider probably mostly subject to what we're talking about today. But any recommendation comes out of a long-range planning study is going to get into the engineering phase, where the public safety and well-being is going to be the top priority.
Any other conversation on this? Oh, excuse me, Candy. As you weren't already up at the microphone.
Wasn't invited. Michael was. And there's one thing Michael said that struck me. He wanted to know cost to determine the level of effort. And there may be another way to get at the level of effort without asking for cost.
I've got ideas. I
don't Okay.
make it about what I'm specifically going to do. I just think there's a clear
I want to raise a new wrinkle with related to planners doing the work if they work at an architectural or engineering firm. Is the firm liable if the planner submits a price? If it's determined that this is planning and not engineering, are there repercussions further down the road?
Other registrants might feel that there is a conflict and would complain.
That's why I'm asking you the question.
The fundamental, in my mind anyway, if we can avoid any potential and still get the best result, why not pursue that path? Because if engineers are desired to be in the pool of those participants to submit on any type of public project at whatever phase it is, and you have control over the cost ultimately through negotiation, why is it necessary to be part of the earlier phases of the procurement? And that's the fundamental message or thought that I have on the whole thing. So
Okay, but that doesn't get at the answer to my question about the firm.
I think people would complain that the firm is breaching the statute, yes.
The firm signs the disclosure form, and we've had this discussion before, that if a firm has a disclosure form, even though it may be submitted by the planning group in that firm, then they would be in violation. Because I brought that up about what if your CEO was a marketing major, didn't have an engineering degree, or you had a business department that just did proposals. Well, since they're covered by, and this is my understanding, y'all correct me if I'm wrong, but since they're covered by the firm disclosure, then yes, they would be in violation of the statute or the rule or whatever this is.
We will get further guidance from you on this at some point in the future.
Like to work with all interested parties to develop an interpretation that's mutually beneficial.
Mr. Chairman, I think there's a clarification here. If somebody whose firm is registered as an architect engineer firm, they do something in violation, when a case is filed against them, the board will follow the due process to investigate that. As of today, if you know of a situation like that and somebody file a complaint that Mr. A, work firm A has violated the law and rules of this board, we certainly will investigate it. So I would think that would be our immediate guidance. That's what I would say. We don't have to wait for any more clarification.
If a client asks for a breakdown of relative effort within a project, like estimated percentage of the overall project, kind of getting at the level of effort that Michael was bringing up, is that in violation if there's no price attached to it? Okay.
So for the record, I would not think there is, because several of the proposals have requirements for organization charts and for personnel to be used on specific tasks and schedules for those tasks. And I mean, I think that's a legitimate idea behind any proposal, is how long is it going to take and who you're going to put on it, so that you make sure that you're getting qualified people on each one of the tasks rather than some junior level or worse out there.
And I've been involved in selection processes where percentages were used and a point system developed or DBE participation had a higher score. wasn't based on fee itself or cost.
Then I have a series of questions about subcontractors, which is something that was raised when I was at a company meeting about a month ago. Ready to move on to subcontractors with regard to the rule? The chairman says yes. Okay. First of all, I apologize. I did not identify myself when I got up here. I'm Candy Toller with the American Council of Engineering Companies of Tennessee, and I'm representing ACEC right now, not necessarily TSPE, although they'll be interested in the answer. Okay. Subcontractors working on local government projects. If an architect or an engineer is the prime professional and the prime has been selected in compliance with the law, can the prime professional request price or cost from a subconsultant?
John, you want to answer that?
Yeah, we've had this question, I think, a couple of times, at least recently. And based on the wording of the law, our interpretation has been that as long as the contract is not with the government agency, then it could be based on price. It's only if you're contracting with the government agency that the QBS law applies.
Can I ask a question about that? When you were talking earlier, I heard you use the term basis of selection or contract in something you were reading from.
Probably the Nevada rule.
No, I think it was something else. But my question is, sometimes the contract is not directly with the public agency, but the selection may be made by that agency. Does that change your interpretation?
Had that question before, so I can't really give you an answer. Let me go back to the statute.
In other words, sometimes it's kind of a funnel through. I don't know if I'm being clear on what I'm presenting here, but.
Well, I mean, the 12-4107 applies to all contracts procured by any municipal corporation, county, state, etc. So if the contract is procured,
Funded by a government entity, I think it would apply, regardless of the.
You're saying that your interpretation is that if it's procured by a publicly funded, on a public, and if it's not a direct contract?
That's how I would interpret.
well, if an architect has been selected through QBS and his contract or her contract is with the government agency, and then like in Candy's scenario, then he subcontracts that. I mean, the contract, he's actually procuring the services, not. So that, I think that's a different situation.
I'm sorry.
Go ahead, Rob.
Well, in the case of Metro government, I know subcontractors also have to be approved by the owner. I mean, it's certainly the recommendation or the selection maybe of the prime contractor, but any subcontractors are also bound by the content of the contract by virtue of the relationship with the prime contractor. So
depends on who's procuring the contract. Yeah.
Michael, you had a comment?
I'd like to share the question with Candy because this is an important question. If the prime is not allowed to request cost proposals from the subs in the development of a proposal, I'm not sure how a prime contract would be able to.
I think the way this was being said is the prime contractor has to be, without price, but the prime could ask proposals from subs.
Correct.
That is permitted.
yes.
Is the line of questioning?
I think that's what.
Well, the selection's been made without price. Let's say a price was negotiated with the prime, and the prime knows what budget they have to then sub the work. But then the subs, in Metro's case anyway, in my experience, the subs also have to be approved, not the price, but the subs that are selected for that project.
It'd be impractical to think that the prime would not consider the budget in making the proposal.
Correct.
So they would need to understand the price information from the subconsultants, even though that may not be shared with the
Wasn't part of the selection for the public project, and I think that's the distinction.
And does the sub have a contract with Metro government? Okay.
They have a contract with the prime. The prime is under contract with the government entity.
I'm still not clear on this.
Okay.
Sub-consultant engineering firm is asked by a consultant on a publicly funded, to Metro,
Okay.
to propose on that project as a consultant to that AE firm.
Has the selection already been made?
Correct.
Okay.
Correct.
Fine. Okay.
Then that firm, that sub-consultant firm, is asked to provide prices.
To
the prime.
That's right.
And the selection may or may not be, Metro may have some influence on the selection, but the prime is we consider that to be a non-cost.
My opinion, again, it's my opinion, is that it would not be, because the public fund aspect of it has already been secured through the qualification-based selection. So how the work then beyond that is distributed, unless distribution of work, like in our case, Mr. Skipper and Metro, there is a component for DBE, and there are points assigned to that for encouragement of inclusion of disadvantaged. But and again, that's based on percentage, but in my experience, in my opinion, any subcontractor work can be, I would say, based on cost, if that's what the prime wants to do, in selecting someone to do whatever subcontractor work that has to be done. Now, any work that the subcontractor does, if there's malperformance, it is the prime owns that responsibility. It does not pass on to the Metro government. So again,
that's how
those
the
are
public health, safety, and welfare is being protected in that
and
situation.
that has been my experience. Yes.
In your opinion, the prime contractor, which is not yet a prime contractor.
We use
before
consultant, the word prime consultant and sub-consultant.
Sure.
A firm interested in priming a team may request pricing information from sub-consultants prior to the selection process. Otherwise, how would they know their ability to?
Well, I'm sure they could, but again, if price is not a component of selection, maybe by the prime, but it's not by the entity that has.
We may not see that pricing information, but the prime can see it of its subs prior to the proposal being developed. Okay.
Just have to express this because this is kind of the world where mechanical, electrical engineers live. When an architect is selected for a public project, we have the same QBS, I think, value for the public for the selection of their mechanical, electrical, structural, civil consultants. We think the same QBS ideals are true, that the public is not protected if the architect then bids out that design work, because there are a lot of health, safety, welfare issues there. I think the spirit of the law is that the architect who is selected would then negotiate and select the best consultants for the project. There are lab projects, there are office building projects, they're all different, and they would select the best consultants, and then they would negotiate as a team with the public entity. I think that's the spirit, but I understand legally that that's probably, that this statute isn't meant to reach down to that level. But I felt like it needed to be expressed that there's absolutely as much health, safety, welfare going on with that QBS selection as there is, and I don't know if we can You know,
I agree with Mr. Bursey. I too am in that industry, and I feel exactly as you do. I think the spirit of the law is that health, safety, and welfare. In fact, my industry is one of the most highly liable. And what I am concerned about in this transition is that the workaround on this will be pushing that liability and that risk down to other professionals instead of at the level of procurement where it needs to be. And that's my concern.
Mr. Chairman, I just want to offer, I think I'm in a similar situation as Mr. Bartram. When we say that after we select the prime consultant, in the prime consultant subcontract, when we say that we have a say-so in the subcontractor, is mainly to make sure they comply with the law. The people are qualified to do the work. Like, for example, in the city of Memphis, we have what are called the living wage ordinances. So you want to make sure the subcontractor is paid at least based on those ordinances and not violate any laws and rules. Well, we understand that pricing has a lot to do with, but that's the last of the things we worry, because once we award the contract, the prime consultant, if he wants to get somebody cheap, yet meet the term of the law, that's fine. But if he hire a bunch of people who are illegal and he's not paying them properly, we have to say so. And then the makeup of it, we had to make sure that this is a minority-owned business, so many percentage that we spell out in our contract that they have to comply to the term. That's what the part where we play when we say we approve and have a say-so in the subcontractor. I want to clarify that. Thank you.
One quick thing. Thank you for raising your placard, and I didn't. I'm sorry.
All right, go ahead.
One of the ways on some of those selections, though, is when we have a sub-consultant or we're a sub-consultant for someone else, I mean, that's in some way the basis for the reason that team is selected in the beginning. And I agree that there is a little bit of a disingenuous thing to think that your team has been selected, but you're going to treat your sub-consultants differently, and they were as much a part of procuring that project as anything else. I will say this, we have a general idea how much that service should cost based on the scope that we have, but we don't ask for those, we don't ask for those numbers until the negotiation begins with the entity. So if you were to say, okay, you've been selected, you've got 2 sub-consultants on your project, I would first of all say, okay, here's your scope. How much is it going to cost you to do this component, this component, this component? Then I would submit that whole package to you based on the sub-consultants that I had on my team, because those are frankly the ones that I feel comfortable working with, that I believe can deliver, and you do as well, from the selection. So now there may be some things where I have to go back to that sub-consultant and say, we can't do this, or that's a little high, or whatever. We need to look at how we narrow that down. But there comes a point during that process, if I think that what you're asking, the pricing is too low to deliver the service that I think I need to provide in those sub-consultants, I need to back away from the project. And instead of trying to, if I think sub-consultant A, what they need is $20,000 to do that, and that's legitimate based on history, and all I'm doing is putting my firm at risk, and I'm putting the public health safety in risk by trying to go get a less qualified firm, in my opinion, to do that kind of work. So I sometimes eat our own, and we shouldn't do that. But anyway, that's my opinion. I'm sorry for violating the placard rule.
Okay. My comment is that on a regular basis, on a state project, and again, for those that don't know, I'm an architect, but we are required at the start of the job to solicit proposals from geotechnical engineering, surveying, and asbestos abatement engineering proposals. Those are submitted on a cost basis to us. We're required by the state to submit a recommendation letter on based on the cost and the services proposed, who the best would be, and that they are not paid by the state directly. We pay the consultant and then are reimbursed by the state. But we send a recommendation letter to the state, and they send an approval letter back saying, yes, proceed, we agree with your recommendation. So that's kind of a fine line there about what we're talking about. By separating it one step away from being paid directly by the state, I don't know if that, I guess that kind of separates it out.
But you're being contracted with the state, and the state, you have an overall contract before you're actually hiring the individuals or approving, okay.
Right. Yeah, this is a reimbursable, not a part of our fee.
Those services you just mentioned, are those registered professionals?
Yes.
Okay.
Yes, like a geotechnical engineer, abatement, that's signed by engineer, and the survey is by a registered land surveyor.
Thank you by saying that that the architect, if that's the prime professional, is not required to go by QBS. You've answered the rest of the questions. Well, no, you haven't. The code citation was changed, as you know, and you've got a proposal in your rules to make that correction. Is there any question about the interim before that new rule is adopted, about whether it's in fact in force?
How about moving the statute number?
Andy, ask your question again.
What is the status of the rule because the law citation has been changed? Okay.
Move it, which we're planning on
I
doing.
understand that part. I'm just wondering about the interim period.
I don't think so.
Okay.
I don't think the legislature would like that.
Back to the comments of Mr. Bursine. If our industry supports this directive, hope that ACEC and TSPE would encourage its members to follow policy or rule consistent with what they're asking to be done. Otherwise, it's hypocritical.
Architects as well. Okay. You might want to recognize the presence of Representative Tidwell. Address you, but at least recognize that he's here.
Have anything to say to us?
I happen to be now the only engineer in the entire Tennessee legislature out of all 33 senators and 99 representatives. And I generally take care of our needs as engineers and architects and things like that. And I guess I have talked to you before about 3 or 4 years ago about a bill that I was trying to get where it more or less drew a line in the sand as to what the oncoming smaller, lesser licenses were taking and weren't taking. We had a bill this particular time that tried to deal with the home inspectors, and we had a problem with them and the fact that some clerks in the Commerce and Insurance Department decided that engineers had to have their license also, which if you go back and get their license, it comes with all kinds of encumbrance like ongoing education requirements and everything else. And we were trying to form the bill into some palatable thing so we could get it through, and having some difficulty with the groups that don't want it to come through, because it puts I guess it puts another opponent into the business cycle with them. So I'm working on that. I don't know where I am good. I've got to rewrite it, I assume, again. But I just wanted you to know this. I came before the board about 4 years ago and told you I was going to get into this, and I'm about neck deep into it. I just kind of drove my line in the sand about the groups that we license and put on board, and then once they get on board, it's their work and nobody else's, and that kind of thing. So I thought maybe we ought to at least take a look at this, and it is your board that decides whether people are competent to do the work, not the clerks in the Commerce and Insurance Department. Thank you. That's all I've got. If any of you have any questions for me, I'll be glad to entertain that.
Well, outside of the home inspection, are there other dual licensing situations that you're addressing?
I didn't hear you. I'm a tad hard of hearing. I work in a plant all my
And I speak too softly. Outside of the home inspection versus engineers performing the same services, are there other dual?
Well, it gets into performing the same work. Now, whether or not you want to use exactly their checklist, I don't know. What an engineer would normally do was create his own list according to what the customer wanted. It could or could not be that list or part of it or more than that list and that kind of thing. But I was getting some objection to the fact that an engineer wants to do anything in it. And certainly the engineer belongs there, because the home inspector doesn't even have to have a high school diploma. He can have a GED. So he's not going to do anything but give the owner a checklist. If it comes into a foundation problem or some more serious problem or an interpretation of code, he's not going to be able to do that. And I just didn't want the engineer that would now have to go in and do something like that, have to go and get his license and comply with all of the things of his license. Yes.
Let me just tell you, I think she's getting at soil science.
Asking about the geologist?
I'm just asking about all the registration boards in general, for instance, surveyors.
Yeah,
Would that give them the right to do home inspections? Do we need to have more clarification in your bill?
You're talking about the combining the geologist with the...
No, I'm just talking in general. For instance, and I agree an engineer should be able to do a home inspection, okay? I don't have any issues with that. But my concern is...
It's not so very important when you look at it like that, but I guess I think it's probably a line in the sand, because I see more of these things coming.
But I think we need more clarification in the way you have written up the legislation, that it doesn't apply maybe to surveyors coming and doing home inspections or whatever, okay? That's where I was.
Yeah, the one I have applies entirely to engineers, and it says this board has the right to just say whether they're competent or not.
I agree with that. Okay?
And it can't be, we can't be forced to go get a home inspector's license when you declared the fellow was competent to make an inspection on the home also, and he could probably do a better job and a more thorough.
Was your bill going to limit it to just that particular situation? Because when I read it, to me, it was more general.
It at first addressed the entire group of people that are what I call the licensing group that the Commerce and Insurance has. And I at first addressed it as that we don't have to go by and buy a license even from a contractor, a soil scientist, or a geologist, or anything else, if you determine that we're competent to do that in order to do it. And the Commerce and Insurance is taking a different stand, and I was interested in addressing that.
Are you speaking specifically for engineers and not other registrants within commerce and insurance?
I was addressing the bill specific to engineers and architects, not to the whole group. But it involves the whole group because the whole group is licensed to do special segments of what we do, I assume. And I don't see, it looks like a bit over-regulation, and it looks like we're asking the clerical group of the commerce and insurance to decide who is qualified and who is not. Thank you.
Mr. Chair, I've contacted our legislative liaison, so hopefully somebody from the department will be coming down to provide us a legislative update if you want to. Maybe we could take a break
I was
for a
thinking we
while.
might want to take a
Okay.
10-minute break.
Just a
I think
suggestion.
everybody's kind of about ready to do that. But is there anything else?
No, I just wanted you to be aware of what I am doing, because it is on your behalf and your membership, of which I am one.
We thank you. All right, let's take a 10-minute break. Convening. I guess we're still under unfinished business. I guess we had one last item, I guess strategic planning discussion. We can make that a quick discussion, I hope.
Okay, yeah, we can. That's page 80, of course, is where that begins. And, this is a discussion that started at our meeting in Cookeville last October, based on a presentation we had at the CLARB annual meeting that encouraged us to engage in strategic planning. We did a survey to identify mega issues of importance to the board. Mobility, upholding standards, and devaluation of licensure were identified as the top 3 mega issues of concern. So if you wanted to proceed with this, I suppose you could identify maybe a task force to further develop one of those issues if there was one particular issue that you felt should be addressed. Or if there's not a lot of interest in that, you could table it for the next planning session, or it's up to y'all.
Anybody have any comment, or would you like to set up a task force to maybe tackle one of the issues and prepare a white paper? I see nobody raising their hands.
Wait a minute, make sure what page we're on.
Ends on
The
page
survey's
80.
on 83 though, correct?
Right, survey starts on page 83.
So the top 3 issues is what we're addressing?
Mobility, yeah.
Upholding standards.
I guess a question of
Oh, please talk into the microphone. Thank you.
I know mobility is something NCWS has worked on for some time, and so have we been availed, I'm sure we have in the past, but recently, since we've identified these mega issues, have we been availed maybe some current statuses on these topics from NCWS?
Yeah, the Mobility Task Force is currently discussing this at the national level, and I do have some information on their recommendations or some mobility-related issues from the meeting in Scottsdale last week that I can share later on, but
That may help us decide whether we want to take further action and not duplicate.
Other efforts.
and they will be presenting a full report, of course, for the annual meeting in August. So, it
Well,
might
that
be
may be
appropriate to wait until October,
then.
perhaps.
Okay.
You said after the national meeting, there may be an October take-up.
And we may defer this till the planning session, so that would be after that, and then we can kind of revisit it. Unless anybody else wants to take one of the other issues and write a paper.
I think it's interesting if you start looking at these items. I know in the engineering committee meeting, we talked about mobility was a big deal we discussed yesterday. It had a huge component, as well as the experience factor and some of these other things. So these issues they're constantly coming to the forefront of what we are discussing on different things. So I think they're important.
especially the devaluation, because I think even the discussion on qualification-based selection as opposed to price selection in relation to being a commodity as opposed in this boards and even nationally, the consideration of allowing persons to sit for the exam, PE exam earlier, and trying to encourage more licensure as opposed to, the decline in licensure perhaps. So I agree with Robert on that.
Guess we'll move on to the new business. Unless there's any other comments? New business. Correspondence from Joseph.
Mr. Chair, did you want to go back and do the legislative update
Okay, let's do the,
next?
yeah, I'm sorry.
I
Yes.
wanna
Do
circle
we have
back.
the,
Yes, I believe we
your
have a
legislative-
representative from the department.
hello?
My name is Chris Kelly. I'm the new legislative liaison here at Commerce and Insurance. I believe that you all have one bill for the 108th session. I believe that Representative Tidwell spoke to you about it a few moments ago. I would be happy to answer any questions. I know that you all also are looking at several other bills, or on your iPad you have, what is it, 1, 2,
It's
3.
on page 38 on your iPads.
You have several other bills. I would be happy to answer questions about those as well. The other bills don't directly affect you, so I probably won't go into too much detail. But I will say that Senate Bill 1450, House Bill 2202, which requires training for board members. It's Somerville, Senator Somerville, Representative Turner has been withdrawn. I know that you all already do that training for new board members, so I wanted to let you know about that. Can I answer any additional questions for you, or?
What's your sense on Mr. Tidwell's bill? What's your thought on its success or progression? Do you have-
That is a great question. I will defer to the will of the legislature. I believe that if it is to pass, it will be amended. We certainly agree that that an engineer is overqualified to do home inspections, although there are some sort of technicalities to do with paperwork and just some things along those lines that we would have to work out. So.
Notice one of the bills was Senate Bill 2053. Doesn't look like it's got a House sponsor on it yet by Bell. It's listed in our package, but it's talking about apprenticeship programs. Is that really shouldn't have any applicability to engineering? We don't have apprenticeship programs.
Right.
I just want to put that on the record. Is that something that we even need to be concerned with? I reckon is the question.
I don't think so. Honestly, that bill is just requesting a study on the feasibility of apprenticeships in a variety of professions. So engineers would not have an apprentice, but maybe you could do it in cosmetology or land surveying or a variety of professions that we regulate.
And then the next question, if I may, was on the next one below that. I don't know if that may have been what you were going to ask on sprinklers.
I was going to follow up with, on the apprenticeship, because whether you're a registered interior designer, an engineer, an architect, landscape architect, our professions are pretty specific as to your educational background and years of experience. And I would hope, when I saw this, I would hope that somehow that bill reflects that we're out of that.
I would be shocked if that did not come out in the study, that it's not something that would be applicable to a profession that requires such strenuous educational requirements. It doesn't work. You can't do it. So, and you were going to ask about, what was the next question about the fire
Senator
sprinklers?
Nicely and Representative Hill's bill on fire sprinkler. And Candy, I don't know, that's a bill I think the engineering societies are reviewing, looking at, if I'm sort of maybe. I know we're against it, but we are too, by the way, but I am too. I just want to know where you think that's going. And maybe we can need to discuss it a little bit more in depth. I don't know.
Right. I think that that bill is very, very narrowly drawn. It's pretty much drawn to affect one church in Representative Matthew Hill's district. I don't think it's going to be anything to worry about, but I would be more than happy to follow up with you all if kind of if you want to track where that bill goes, I'd be happy to send a report. And good to know that you are all against it.
I'm sorry. This board worked pretty hard to get that requirement and put a lot of effort into this fire sprinkler requirements, and that would be a step backwards, I believe, in our case to do that. So, okay, I'll shut.
No, I feel free to voice all concerns. I think that's very valid, and I personally agree with you. I don't know where it's going to go, but we will certainly watch it on your behalf. You don't want to regress.
A follow-up on the sprinklers, that you have the fire, you have the building codes which specifically address it, so, you would end up, if they try and do this, you would need to go back to the building code, to the appropriate building code, and have that changed in that, because what affects Tennessee, what is done in Tennessee, could affect the same situation in other states. So it's not something. This is not something unique to Tennessee.
Do you mean it would set the wrong precedent, or?
It could set up, if this were to be passed, it could set up a precedent, and this is actually under the building code rather than a state code. The state does not have its own building code. The state goes by the international, the ICC codes for what's done in architecture, engineering, mechanical engineering, and so forth. And the fire marshal would probably want to have some say in this as well. That's somebody else that needs to be considered.
That was actually my first thought, is how very upset they probably are about this. Okay. All right. Is there any other questions?
As the interior design representative, I want to chime in with our engineering and architectural representatives that we wouldn't endorse anything like this as well. Many churches are used as shelters during emergencies, and why would we not want a sprinkler system where we have groups of people that are there under dire circumstances? So I think we need to fight it. Okay.
One other comment on, I'm sorry. Sure. Sorry, Philip.
Go ahead. Since you got started, go ahead.
Well, Senate Bill 2345, Ketron, it's the Tennessee one-call bill. I think it includes, although not listed here, the provision, unless it's changed, that even for design services or that utilities would be compelled to locate underground utilities for design considerations. I'm an engineer, but I'm also a utility purveyor, and one of the concerns on the utility side is the additional cost to the utilities to go out and locate underground infrastructure for the purposes of design. And typically or historically, design consultants' due diligences have included going to the respective utility and getting what's called as-built drawings, which are drawings that are based on the actual construction of the infrastructure to get information as it relates to, additional designs in proximity to those underground utilities. And I'm concerned that if, as written, unless there's a modification to the bill, and it still includes the requirement of a utility to locate for design purposes, that it will be viewed as costs passed on to ratepayers that might be viewed as excessive. So I just want to raise the consciousness of this. I think, Candy, is TSP or ACEC, have they taken a position on this? And what is their position? Support it. Okay. I think fundamentally the objective is good, because certainly as much damage prevention as can be prevented in design of infrastructure that will again be in proximity to utilities is a good thing. But again, the burden of it being on the utilities and subsequently the ratepayers of that utility might be viewed negatively. Okay?
Absolutely. We track about 300 bills, and this one in particular I have not spent a lot of time with, so I don't want to give you the wrong information, but I think that you have raised some very valuable points that I don't know that we had thought of in terms of how that would be funded. And I would be more than happy to send you our legal analysis on the bill.
It's amazing that I'm an engineer. I work for utility company. It's the same thing I wanted to bring up about. Right now, any of my design profession who actually will go out and locate before we do any design, it will slow a lot of the process down. And I think it's going to add a cost to serve the public implication. Yet we have a mission to serve our customer cost effectively, reliably, and safely in our services. So a lot of time when we get through a design, we have what I call another phase where pre-construction meeting. And just before they actually go out, start digging out, they had to do the 811 call, Tennessee 1 call to locate. And at that time, if there's any interference that they find, it's a result that you go back to the designing table and we have a lot of as-built drawing that we use in our design phase. But the other thing is also this bill doesn't address, but I think it's somewhat accepted. What happened in the emergency situation? How do you deal with that? Let's say you're a major metropolitan where you have a downtown network system that's got dug in by a contractor, and then it's going to shut down half the hospital. The ability to operate can impact commerce and business. Thank you.
Thank you very much.
Make one last comment on this bill, and I know you've not studied it, but I think the opinion given was more from a utility perspective, not necessarily from a board perspective.
It is. But it's
It
a
is.
public- but it's
We're proud of that
ratepayer.
too. Okay, we're proud of that.
But
So.
public ratepayer concern.
Right.
But, I mean, there's other, and I don't know that and the reason I ask that is do we need to take official positions on any of these bills, or?
It's up to you. There's certainly no requirement that you do so.
Because and I'm not
It's
trying to pick
entirely
off
up to
how, I
you.
just want to make sure that before if there's anything that we need to take a position on, now's the time to do that and see as a board which ones we need. And I don't know, defer also, we postponed Candy's. Are there any bills that you all are monitoring as well that the board might potentially have to take a position on? And can we kind of have that discussion, Mr. Chairman, maybe in concert a little bit, so that because we're going to have to take some official position, if we do or don't, I'd like to do it all at one time.
Okay.
Does that make sense?
Yes. Candy, you want to? Don't go away.
Yeah, don't go away.
Bill 1740, Candy Toller with ACEC of Tennessee. Senate Bill 1749 with the sprinkler requirement was one of those I was hoping that you would oppose, because both ACEC and TSPE are public safety. That's the primary one.
I'm looking at your email, Candy, and the one I that I thought might be of interest to the board is the one that deals with allowing all pipe materials on water and wastewater projects. Seems to me that is a decision of the design engineer, not of the legislature. So that might be one.
Yes.
That is House Bill 2210. You're number 5 in your email.
Now?
As a point of information on that bill, I'm a chair.
Your mic.
On the same bill, from the American Water Works Association, we are also in opposition of that bill for the reasons that Steve cited. And I think something we do need to track.
That bill calls for a study by the comptroller, but legislation to this effect was introduced in Indiana and Ohio, and it was stopped in Ohio. That was not a study. This is just a study.
Driven by the plastic pipe industry.
ALEC model law.
I know we have Ashley Cates here with the AI Tennessee, and I believe their position, and Ashley, you can express it, on the question of the sprinkling of the church. AI Tennessee is also opposed to that.
So do we want to take a position?
I'll go ahead and make a motion that we, as a board, oppose Senate Bill 1749, House Bill 1649, for the purpose that it reduces the public health, safety, and welfare. Well, it does reduce the public health, safety, and welfare, even though it may be narrowly written. Those things have a way of expanding, and it would be of concern of mine. So my motion is that we oppose it based on the basis of public health, safety, welfare. My comment is they tend to mushroom, and we've kind of dealt with that some on masters and different things where they end up kind of migrating and making unintended consequences. So I would make a motion we oppose it.
I second that motion.
I have a motion and a second. Any other comments, discussion? All in favor, say aye.
Aye.
Opposed? Is there any others that we want to take action on?
Mr. Chairman, I'd like to kind of bring up Senate Bill 1504 and House Bill 1517 by Tidwell and Green. And I believe, if I remember, my memory serves me correctly, that time we took a position, John, I don't have the minutes in front of me, back in 2010. I think the board support his position.
Actually, the board did not take a position
Okay.
on it at
I
that
thought
time.
maybe it was me thinking out loud. So, but I think I'd like to actually make a motion. We support his position in what he's presented to us today and in what is in his bill as written.
Do I have a second?
I'll make a second for purposes of discussion, please.
Okay. Now you may.
Do we know exactly what's in his bill? I mean, the reason I ask that is we've got a pretty good handle on the limits that we think engineers and architects, landscape, we understand what they're capable and competent to do. Does this bill potentially open it up to unintended consequences? And I'm trying to understand. I understand the purpose of the bill. I understand the thrust of the bill. But how wide ranging, and I've not read the entire document of this bill, is this?
And it's going to be rewritten.
Yeah, and it's going to be rewritten.
That's what I was going to say. I could run through all of our analysis right here that I have, but I think probably before you take official position, I would wait until the amendatory language comes out, because it is going to be make some pretty substantial changes. That would just be my recommendation. You're more than welcome to vote today if you feel very strongly.
I would, based on those comments, is there a way that we can still do an electronic vote on this if we need to take a position based on the amended? Because the revised language may come out next week, and we're not going to be meeting next week, next month, whenever the session is.
We meet in April. They're going to be concluding in mid-April, I think.
Yes, sir. This session is moving pretty quickly. My recommendation, can they take an electronic vote? No?
We have until notified to the Secretary of State.
Okay, probably not. What my suggestion there would be to just work as individuals through your associations, and it would achieve the same effect.
Let's say, Mr. Chairman, I'd like to withdraw my motion.
I would point out, too, that just be mindful of the fact that other boards are also interested in this legislation, such as the Surveyors Board. Home improvement program, et cetera, or home inspectors, I should say, yeah. Based on that should inform your, I guess, decision whether to take a position or not.
He's withdrawn his motion in the second, so we will do as individuals try to support him when we see the legislation.
Candice?
Candy?
Thank you for reminding me about that second bill. I would appreciate it if you would oppose that bill with ACEC and TSPE because we think goes into the realm of the practice of engineering.
For the record, can you read the bill out again?
It is Senate Bill 2199, House Bill 2210, related to piping material.
I have a second.
Second.
Thank you. Any other discussion? All in favor?
Aye.
Opposed? Passes. Anything else? Any other legislative issues? Then we'll move on to,
Mr. Chairman, I think
Yes.
as a note, it's been very helpful. Thank you.
thank you very
Thank
much. But you will keep John informed, and then he will in turn keep us informed. Thank you. Okay, now we are into new business, I believe. Correspondence from Joseph Carson. We've already dealt with that. All right, good.
I don't, did the board as a whole
The
take?
board did not vote for it.
That was part of the
But
report.
The committee has reported
Committee
as a.
reported, so now let's,
The committee.
so the committee wants to make a recommendation to the board as a whole.
We just recommended, and John, do you want to?
No, I don't. No.
So basically, our committee is recommending to the full board that we respond to Mr. Carson's request for a response by virtue of two things, that we don't believe that there's any actionable items at this time on the part of the board, and if he has additional information in the future and not just repeating past information, then we would certainly take it under advisement. But unless there is additional or new information, then we are, by virtue of this notification, closing our efforts on the matter.
Now, I guess now, since it's,
That's the report.
that's the report, do I have a motion to that effect?
Engineer committee was going to make an informal motion or recommendation, right? What I thought.
So we make a motion to respond to Mr. Carson's inquiry with content in the letter to include that we don't believe that there's any additional information presented that is actionable on the part of the board, and unless there is new or additional information that he wishes to present, that no other attention will be given to his request.
Second.
Second.
Okay. Ricky?
One other thing we talked about in the committee meeting, just looking at notes, was that was one aspect, if there's no new information. The other was that in looking at our rule 0120-02, work on a project that's detrimental to public health, safety, and welfare. Discuss that as being the other thing in a or file a complaint against him for saying things that are not truthful.
Part of our discussion yesterday was was to respond to his inquiry without it being to respond in a manner that is conclusive, but not in a manner by which he would be open to response. So I think we just want to word the response in a manner that it is not, that is pretty final at this point, that we don't see any actionable item or issue. So I guess, we're in the discussion phase, so if this motion passes, John, then maybe a draft could be circulated for anyone that wants to participate in the final draft to have an opportunity to make sure that it meets the spirit of what the committee was recommending to the board.
And I mentioned that because I didn't know whether the motion that you made that left out reference to the rule, whether that was by design or whether you feel like
By
that.
design.
Okay, because it would entangle the discussion, and I understand that. I just want to make sure.
I also want to just for the rest of the board to know, and for somewhat on the record too, well, it is on the record, I reckon, if I'm speaking right, that our law and rule does not say that the engineer has a responsibility to resign from their job. The law and rule says that they have a responsibility to cease on the project. So that could be one of many projects they're working on in that job, or it could be in an advisory capacity as a consultant where you're being asked. And Mr. Carson's request has been, should he resign from his job? Our law and rules don't state that. They say, and we don't know if Mr. Carson has resigned from the particular project that he is referencing allegations about. And I will also say this, and this is speaking from me personally. The other allegation, the other thing is he wanted to be disciplined for making false statements. In my dealings with Mr. Carson, I've never gotten the impression that he has made statements that are knowingly incorrect. We may have a difference of opinion on those statements. We may interpret facts differently, but I've not ever known that he has made statements that are false, and therefore to discipline him for something that's strictly a difference of opinion or a different interpretation of the facts would be it would be a wrong application of our rules. So I wanted to put that as further detail behind what we're discussing. Thank you.
Susan?
I believe in our letter to him last year, we recommended that he consult with his attorney regarding his position. Are we going to add that to our letter again this time?
That could be considered, but again, part of our discussion yesterday was to respond, certainly as a professional courtesy, but in a manner by which we didn't leave anything open for a response or advice might be considered something that he would maybe can be compelled to respond to. He may be compelled to respond anyway, but we were just trying to be, address the issue as requested in the best of our ability to be able to move forward. So, John, if the motion passes and John drafts a response, then certainly I would encourage us to allow all board members to have access to it and be able to weigh in.
Further discussion? All in favor of the motion, please say aye.
Aye.
Anybody opposed? Motion carries. Now, we are to commissioning policy.
Okay, that's on page 85 on your iPads. This is a policy based on a decision that was, or a response that was sent out by the engineering committee in December, I believe it was, or was it October? I can't remember now. It's fuzzy in my memory, but a response to a question that we had received about commissioning of engineered systems, whether a PE would be required or not. So this is just the same wording, I think, that was adopted at that time, and this mirrors the policy, the position statement, rather, that's been adopted by NCEES on this issue. Since this is potentially going to become a FAQ, I thought it would be advisable to formalize this as a policy that would be placed on our website for future reference.
John, I'd suggest that we put in design professional services, because this is not limited. When I looked at this, this is not necessarily limited to engineering. It could involve architectural services as well. I would feel more comfortable if we can encompass all the professions.
Change the title of the policy to?
No, not about engineering systems, but that a licensed professionals. See, if we just limit it to engineers, it's limited to engineers, but this could involve architects as well.
Okay, under the practice of architecture or engineering. It must be performed under that last paragraph, just change that to, it's our position that commissioning of those systems that are engineered systems falls under the practice of architecture or engineering and must be performed under the responsible charge of a registered professional architect or engineer. Is that
Registrant, why don't we use registrant?
just a registrant of the board? Okay.
Yeah.
Falls under the practice of architecture, engineering, and landscape architecture, or just?
Still want to
No,
stay
those
out of it.
systems.
You want to stay out of it?
Well, I would, but I'm thinking about outside systems. We do inspect and, different types of systems, but not what this is talking about. I'd just say architects and engineers.
It might be that you would put some verbiage in there that said it would be commissioned by the licensed professional that provided the design. In other words, I'm not sure I want to do the commissioning on a HVAC system. And commissioning of the architectural portions of a building are a lot less than the MP&E part of it is. Screws in the hinges, but you know what I'm saying. But there are some aspects that would be, but I don't think you'd want architects and landscape architects checking out the HVAC system. What I'm saying, that to just, if you do revise it, put it that the commissioning would be done by the profession that provided the design somehow or other, not.
Just offer a language consideration then. So on that sentence, commissioning of those systems that are engineered systems fall under the responsibility of design professionals and must be performed under the responsible charge of a licensed registrant or generic, but specific on what we're seeking to a policy on.
Another option that may be clearer is you've got that last sentence there that talks about commissioning of engineered systems falls in the practice of engineering, must be performed under the responsible charge of a professional engineer. It might be clearer to add another sentence there. This is when you're commissioning, and I'm trying to think of the proper term, construction items that fall under the practice of architecture are commissioned by a registered architect. I think that would be clearer than trying to make the statement so general that surveyors and landscape architects can check building systems.
I think I understand what you're getting at, but I think it's the sentence needs to say something like the commissioning service shall be performed by the applicable applicable registrant expertise that has that expertise. And you may have a land surveyor that has some expertise in a commissioning that could, and I don't know what that is off the top of my head, but
Yeah.
but I think to make sure that they have the expertise, that's what we're trying to, both of you I think are trying to get at.
Oh, I'm sorry.
Do we have a motion?
Sounds like we probably need to do some work on it and then present it at the next meeting for adoption, because, we'll have to be very clear and precise on the wording that we're adopting.
John's suggestion, maybe you could come up with a draft and circulate it so that we have a little bit of time to look at and respond back to you so that we can address this at.
Work on it and then get back to it at the next meeting.
Next
I
meeting,
think.
okay. We're at the next item, call for officer nominations. And since Wilson's not here, who's,
Yes, you can do that.
well, I can call for the, what is the next,
Well, the way it occurs based on our bylaws is that it's just a general call for nominations at this point. Anybody that's interested could put their hat in the ring. Based on our rotation, let's see, Rick is currently vice chair, so he would normally rotate to the position of chair. Robert would move into the vice chair position, so that we'll need a nominee for the secretary position. Based on the suggested rotation in the bylaws, I believe at this point, it would fall to either a landscape architect, interior designer, or the public member, because we've had an architect and engineer, so.
either the public member or the, interior design?
If following the suggested rotation in the bylaws, that's just a suggested rotation. It's not required that you follow that procedure, but that's the rotation that's
Quick question.
recommended.
Susan, didn't you used to be a chair up here, right? Were you a chair person? Maybe I was thinking of somebody
We
else.
haven't had an interior chair since I've been on the board, I don't know.
Long time since Linda Smith was
Yeah,
here.
since Dana Miller was the last one that we had.
So it may
Public
be,
member was chair.
Right.
That was Brenda.
Yeah, we've had the public member, the landscape architect, so normally it would fall to interior design, following that
I have
recommendation.
not,
I nominate Ms. Ballard
Okay.
to serve as secretary.
Second to Dan.
The way this will occur, the nominations committee will meet before our next meeting, and they'll present a slate of nominees for the board's consideration. The voting will occur at the June meeting, or wait a minute,
A June
July
meeting,
meeting.
okay.
No, wait a minute, wait. April, yeah, June, that's right. I'm going back to the old schedule here. The June meeting is when y'all will actually vote on those nominees.
Take office in July, yeah.
Right, take office July 1st.
Okay. So, that taken care of, report on the NCEES member board,
Okay.
administrators meeting.
We ran out of time at the engineer committee meeting yesterday, so I didn't really go into this report. I got quite a bit of good information, so with your indulgence, they spend a little more time on this than normally would, since we didn't go over it at the committee meeting yesterday. Got a lot of reports from committees at this meeting. It gives us a sneak preview of motions that will be resolutions presented at the annual meeting. The committee that's charged with exam policies and procedures is going to recommend that we keep foreign exam results separate from U.S. results. That's an issue that's arisen due to the engineering exams being offered in increasingly more foreign jurisdictions, including, I think, Turkey, Egypt, used to be Egypt, those are suspended currently, and South Korea, Japan, there have just multiple locations. So there's a lot of foreign examinees. So the question has arisen, well, should those results be factored into determining the cut score for those exams, into the statistics, the pass rates, et cetera? So it's been they're going to recommend that to keep those results separate from U.S. results. They're also going to recommend to revise policies to allow individuals who teach FE exam review courses to allow them to proctor the PE exams. That's not allowed under the current policies because previously the same individuals would proctor both the FE and the PE exams when they were written exams, but now only the PE exams are written. The F exams are computer-based, so there's no danger in allowing them to proctor the PE exams. They're not going to have any exposure to FE candidates. Those are all done through Pearson VUE testing centers. So that's one revision they're going to recommend. The Law Enforcement Committee is discussing a motion. I guess this would be a motion for a committee to study revising the model rules to state that licensees shall not use confidential information coming to them in the course of their assignments as a means of making personal profit without the consent of the party from whom the information was obtained. Sort of like an insider trading prohibition that you can't use confidential information for your profit. Yeah, I'm sure this will generate a lot of discussion in August. Licensees shall not use confidential information coming to them in the course of their assignments as a means of making personal profit without the consent of the party from whom the information was obtained. And here's some justification for it that I was handed by one of the committee members. Virtually all professional ethical standards prohibit the disclosure or use of a client's confidential information without the client's express consent. Model rule such and such, I won't give the citation, expressly prohibits such disclosure by professional engineers and licensed surveyors absent the client's consent or as required by the law. But the rule does not address a licensee's use of such information. And then they give this example. This is a surveying example, but it could apply to engineers as well in other contexts. Licensed surveyor is engaged to prepare a survey of a client's parcel 1. During the course of the engagement, client requests that the survey be prepared in a specific manner because she intends to purchase adjoining parcel 2 in approximately 5 years for a development that requires both parcels. Based upon that information, land surveyor subsequently purchases parcel 2. So that's one example they provided for us. So that's the basis of their recommendation there. So I'm sure that'll be discussed further at the regional meeting as well as the annual meeting. And their motion would not actually change the model rules. A committee would be charged with amending the rules as according to their recommendation if it passes. Also, the uniform, well, I'm not going to give you the acronyms, it's too much. There's a committee has been charged with amending the model rules to decouple the experience requirement from the exam. So the timing. issue that we've talked about. And I had the open forum to discuss yesterday. So there's a committee that's going to recommend decoupling that experience requirement from the exam requirement. And we were reminded that only applies to the PE exam, not the PS, the surveying exam. There was some confusion about that among the boards. There's a foreign experience task force. Hal is serving on that task force. They are recommending to develop a database providing license requirements in foreign jurisdictions and a database for international engineers. Did you have anything further on that, Hal? Okay. The mobility task force, this touches on one of our mega issues, discussed a recommendation that came up last year to develop an enhanced model law engineer status where you would, these individuals would be subjected to background checks to facilitate licensure. They decided that an enhanced model law engineer status would not be beneficial, partly because only a few jurisdictions currently require background checks, and the requirements vary widely among those that do require it. So they decided it wouldn't be beneficial and would not address the mobility issue, but would only help a small number of applicants. So they're recommending instead some model law language to assist with mobility to the effect that if a COMITE applicant has passed both the FE and the PE exams and has practiced for 10 years or some other amount as determined by a state without incident, with no discipline, then a license would be issued, I guess, with no further requirements being imposed. That's the proposal that they're discussing. It may change over time before it's presented at the annual meeting. Well, that came up, and they haven't really discussed the education component, which would be a big stickler for us in Tennessee, of course, since our education requirements tend to be more strict than many other states. So I don't think they've fully discussed the education component at this time. But the argument was made by the person presenting this that, you know, one state shouldn't try to second guess another state. If another state has determined someone's qualified to practice, they've been practicing for many years without incident, then we should not question their application in our state. That was the argument that was made. They also have been discussing greater uniformity in continuing education requirements among states, which is an issue, of course, the architects have been discussing for several years that our pending continuing ed rule change is intended to address. The engineers are just getting started in that discussion, and apparently they haven't gotten very far with it because they've been focusing on the COMITE issue, so they haven't really gotten to the continuing education component at this time, but they are interested in pursuing greater uniformity there. NCAAS, some staff reported that they are going to begin tracking continuing education for record holders. So I think the decision's apparently already been made to provide that service to record holders. They asked the member board administrators if there was any interest in NCAAS approving courses and providers, and I think the consensus was that probably was not a good idea. It'd be best to leave that to other organizations. That I don't know. I haven't checked that in a long time. I know there's an initial fee to establish it. The renewal is significantly lower than that each year, but if you transmit it, there's an additional fee. Wanda, do you remember what the fee is for transmittals? Okay. Not sure what the cost is. The Member Board Administrators Committee has been discussing how to proceed with the master's or equivalent or bachelor's plus 30 provision in the model law, which is scheduled to be implemented in 2020 because no states have adopted it to date. So there's concern that if that 2020 date remains unchanged, that at that time there's going to be very few model law engineers that are engineers that are going to meet that standard. A lot of those who are currently hold a model law engineer record will no longer be model law engineers because they don't have that additional education in their record. So that they're encouraging more discussion about how to proceed with that, whether it should be struck from the model law or simply pushed further into the future.
Shouldn't that be a hint?
That no states have adopted it?
5 years away, plus or minus.
Yeah.
And no states have adopted it. Shouldn't that be a hint? Just
Yeah.
suggestion.
So there may be a lively discussion about that in our future meetings, just a heads up on that. Update on computer-based exams. I think Hal mentioned this based on some information we received from Davey McDowell of NCWS, that the numbers are looking pretty good. That's the general feel for those that have signed up for computer-based testing for the FE exam. One area of concern they pointed out at our meeting is that 1,184 individuals are registered but not authorized. That's not the primary issue of concern. The main issue is 2,385 candidates are authorized by a state board to sit for the exam, or by NCAAS if they're an automatic state, but they haven't scheduled their exam yet. And they're not sure why there's so many, over 2,300 candidates sitting out there that have been authorized to sit, but they haven't scheduled yet, when there's so many test dates. No, actually, yeah, well, maybe that's it, yeah. Maybe it's the cost, yeah, that could be part of it. But they speculated, well, some of them may be waiting to see if a certain exam site is going to open, because there's some sites that are still pending that will be opened in the future that are not yet available, or they may be uncertain of their class schedule. That could be part of it as well. Robert?
Do they not have these people's emails that they could send out a survey and ask them why? Or have they already?
They're thinking of doing that, yes.
I would think a little faster.
Yeah. As of last week, they weren't exactly sure why that was occurring. Let's see, early testing, which we discussed yesterday. I mentioned to the engineer committee, Ohio is the only state I know of so far that's come right out and said, you know, if a candidate takes their exam before they complete their experience in another state, if they come to our state, they're going to have to retake the exam. So far, they're the only state that said that. Anecdotally, I understand there may be a few other states with that position, but they appear to be in the minority. So I'm not sure that the mobility issue is really going to be as big of an issue as some think it would be, based on our discussions last week. Also, some of you may be aware, recently several jurisdictions, including Kentucky, I think North Carolina, signed a memorandum of understanding with Japan for reciprocal licensure. We were told that the Japanese don't generally seek a license in the U.S. in order to practice here. They generally stay in Japan. The reason they want a U.S. license is because of the prestige that it carries in their country. They want to be known as PEs, have a U.S. license. So apparently it carries much more clout there than it even does in this country in industry. It was pointed out that MOUs with other countries help our registrants obtain licenses elsewhere, so it actually helps both parties. Industry in Japan values PE licensure. They want their engineers in plants in the U.S. to be licensed as well. So Kentucky and other states that have those agreements said that over time, those agreements might help to attack industrial exemptions in our country, because Tennessee, of course, does have some plants, like in Smyrna, my town, Nissan. So that could be a way to encourage that. But I thought that was interesting information. I'm sorry? No, I haven't had time to compile a written report. I can do that if you like, for your, just your information.
Hey, John, I thought that you and I attended last year at the Southern Zone meeting, no, all member board meeting in Atlanta. One of the things they talk about that, I believe Jerry Carter or somebody came, or even either McDowell came up and said that they are reaching out to the Japanese engineers. I think they have some way to administer the exam. So what I'm bringing it up is the encouragement for a way to actually license foreign registering is good thing, because you think about it for a minute, you got Volkswagen now in Tennessee, you got Nissan, and you had Toyota, which is in Mississippi. And who else? And Denso, yeah. And the Electrolux is one of my largest customers in the mixed appliances in Memphis. And then you have Mitsubishi, the big power circuit breaker. Those are good things that's happening in our community.
Of course, we have a pending rule change to repeal our residency requirement for exam applicants, so that might help facilitate licensure by those taking the exams in foreign jurisdictions. And also, but one impediment that we have, it could be viewed as an impediment, is the requirement in our rules for engineers that they have at least 1 year of experience in the U.S. And that's not uncommon. There's several other states that have similar requirements. But that might pose a problem if somebody that's in Japan is applying for licensure here.
I'd really like to add that when we meet with the dean the next time, those dean college of engineering, because we've been encouraging their professor to register. Most of them have foreign degree, and maybe through this trend we might be able to bring more PhD and become a PE.
Okay.
Thank you, sir.
Anything else? Anything else before the board? Any other comments? Do I have a motion to adjourn?
Move.
Do I have a second?
Second.
All in favor?
Aye.
All right.
Good meeting, Mr. Chairman.
Fine, I have a question for y'all. It's a follow-up from December. Do you want us to continue making hotel reservations for you?
We said no.
Yes.